First we'll start with the company law. Okay, so then we'll go to the industrial laws. If you see, we'll go one by one the important topics. These are the essential features of company that may not be important for the exam. Government company definition is important. So which company can be called as a government company? Government company, central government or state government should hold, central government or state government should hold 51%, at least 51%, at least 51% of what? 51% of paid up share capital. Or other government company, or one government company can hold shares in another government company. Okay, another government company. Okay, so this another government company can hold either more than 50% of total voting power, more than 50% of total voting power, or controlling the appointing or removing all or majority of directors. Okay, appointing or removing all or majority of directors, appointing or removing all or majority of directors. So in the practical question, it is very important. Okay, either we should not club the control by the central government and state government and the government company. We should not club both. If you are taking the government control 51%, and that is also paid up share capital. No sir, we want to take the government company, another government company. It is more than 50%, that is of total voting power, or appointing or removing all or majority of directors. That is to say, this government company will become a subsidiary company and this is a holding company. Okay, if holding company is a government company, subsidiary company is deemed to be a government company. So this A, B points is nothing but subsidiary holding definition, not new points. These are subsidiary holding definition. If a company which is subsidiary to government company is deemed to be government company. It is a company like say DEF Limited. So it is a company by name DEF Limited, and DEF Limited is a subsidiary of ABC Limited. DEF Limited is a subsidiary of ABC Limited. If ABC Limited is a government company, then DEF Limited is deemed to be government company. Okay, so therefore here we are applying the definition of government company. The mistake in the examination will do in the practical questions is mixing these two, central government, state government, or another government company holding 51%. Don't mix this, either this or this option. Both are independent. Okay, either you have to check any one of these. We should not club, say central government, state government, another government company, central government, state government, another government company. Okay, so if the central government holds 30% and state government holds 20% and another government company holds 10%, total 60%, this second company will not be treated as a government company, because it does not satisfy any of these two alternatives. It does not satisfy this alternative, and also it does not satisfy this alternative also. Therefore, don't club and say 30 plus 20 plus 50 plus 10 is equal to 60. No, you should not club these two. Take only these two, or take only this third one. Okay, don't sum up all the 1 to 3. Okay, so that is the reason I have given two different things. If central government or state government is controlling, it is at least 51% of what? Paid up share capital. So if another government company, you have to apply the holding and subsidiary definition. Here more than 50%, more than 50%. Here it is paid up share capital, here it is total voting power. Here another alternative is there, that is appointing or removing all or majority of directors. Okay, right. So there is a chance of theory question and as well as practical question also on this definition, government company, easy definition. Next, associate company definition is also important. Company 1, company 2, company 1 and company 2. If company 1 is exercising significant influence, if company 1 is exercising significant influence over company 2, okay, if company 1 is exercising significant influence over company 2. Now, so which company is an associate company to which company? That is the important point. Which is associate to whom? In the MCQs, we should not confuse which is associate to whom. Which is associate to whom? Company 2 is associate of company 1, but not vice versa. Company 2 is associate of company 1. That means influenced company is associate company, not influencing company. Okay, this is influencing company and this is influenced company. Influenced company is associate company. So in whose balance sheet will disclose the associate company? Very important. Company 2 is treated as an associate to company 1 and it is disclosed in the financial statements of company 1, not in company 2. That means if it is ABC and it is DEF, in the ABC financial statements they will say DEF is our associate. DF is our associate. In DF they should not say ABC is our associate. Okay, so ABC second company DF is treated as associate to the first company. So which company is associate to which company? So which is associate to whom? That is important. Company 2, that is influenced company, is associated to the influencing company. In the financial statements of company 1 will disclose DF as a associate, but not in the financial statements of DF. DF is associate to whom? To ABC. Therefore, in the ABC financial statement, they will disclose DF as a associate, but not in the DF financial statement. DF financial statements, they should not disclose ABC as an associate. Okay, that is important point. But in this company, influencing company's financial statements, they have to disclose this DF as a associate company. Okay, influencing company and influenced company. Influenced company is an associate to influencing company. Influenced company is associate to influencing company. Sir, what is this significant influence? Significant influence, at least 20% of voting power, minimum 20%, maximum 50%. Why maximum 50%? If it crosses, it becomes a subsidiary. Associate and subsidiary are mutually exclusive. Associate and subsidiary of mutually exclusive. If DEF is a subsidiary to ABC, then DF cannot be associate at the same time. DF cannot be both subsidiary and associate to ABC. Either it can be associate to ABC or it can be subsidiary to ABC, but not both. DF can be either associate to ABC or subsidiary to ABC, but cannot be both. Therefore, if it crosses more than 50%, if it crosses more than 50%, it becomes a subsidiary company. Therefore, maximum 50. Maximum 50. Okay. So DF company, significant influence means minimum 20%, maximum 50% of what? Of total voting power. Of total voting power. Or participation in business decisions. Participation in business decisions. Participation in business decisions. Any one thing. Okay. Participation in business decisions. Minimum 20%, maximum 50% of total voting powers or participation in business decisions. Okay. That is what the associate company, influencing company, influenced company. So if company 1 is having significant influence over company 2, company 1 is having significant influence over company 2. So company 2 will be treated as associate to company 1. Okay. So what do you mean by significant influence? Either 20% to 50% of total voting power or participation in business decisions. Okay. That is the associate company definition. Next, foreign company definition is important. It is not, it will not be there in the CA Inter. Okay, so those who have, so this is important definition. Foreign company. So foreign company means a body corporate incorporated outside India. Incorporated outside India and has a place of business in India directly or indirectly. Okay, and conducts business activity in India. And conducts business activity in India. Okay. Company incorporated outside India. Company incorporated outside India. Okay. Company incorporated outside India. Has a place of business in 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 India. Either directly it has a place of business or it has one agent and that agent is controlling this business. In both the cases, it is treated as a foreign company. Company incorporated outside India, it has a place of business in India either directly by itself or through agent, or the agent is controlling that business place, and this business place may be physical place or virtual place. Even without any physical premises, if they are doing online business also, it is treated as a place of business. Okay, physical or virtual, directly or indirectly. directly or indirectly. So directly by itself or through an agent, physically or through electronic mode. There is high chances of testing practical question based on this electronic mode. A foreign company which does not have any physical premises in India but is selling its products through online. Okay, then also it is treated as a foreign company only. Without opening any office in India, if they are selling their products through websites, deliveries at India, then it will be treated as a foreign company. Okay, has a place of business in India directly or indirectly through agent, either physical place or virtual place. And just having a place in place of business in India is not sufficient. They should be actively engaged in business and doing business activity in India, and doing business activity in India, and doing business activity in India, and doing business activity in India. Okay, incorporated outside India, has a place of business in India, and doing business in India. Okay, and doing business in India. Right. So if you are not doing business in India, even though you have one premises, say for example, you are doing simply some research in India, that's it. You are doing some agriculture research in India. Neither you are not purchasing any raw material, you are not doing any production, you are not selling nothing. Just you are doing some research. It cannot be called as a foreign company. Okay. So it must be actively engaged in business activity in India. Doing some business activity in India. Okay, 3 points. Company incorporated outside India, has a place of business in India, and doing some business activity in India. That place of business may be physical or virtual place. This is very important. Electronic mode. Okay. Next, small company definition. Small company definition. Actually, there is an amendment in the small company definition, but that amendment is not applicable for your December exam. Okay, so your December exam, all these 6 months amendments will not be applicable. Only amendments till May 31st will be applicable to you. But somewhere the small company definition amendment is somewhere in the month of October. Therefore, that amendment is not applicable to your exam. Okay. Small company definition, but in the exam, if time permits, you can write a note point. There is a limit. Small company definition, maximum paid up share capital 2 crores, turnover 20 crores. So this has been made as 4 and 40 crores, but that is not applicable to you. Okay, maximum paid up share capital, maximum paid up share capital 2 crores and maximum turnover 20 crores. Maximum paid up share capital 2 crores and maximum turnover 20 crores. Okay, right. This is small company definition, which is small company, which is small company, which is small company, and which are not small companies. Okay, there is a big list of which are not small companies. Which are not small companies. So first one, public company is not a small company. Section 8 company is not a small company. Holding company is not a small company. And subsidiary company is not a small company. And statutory company is not a small company. Statutory company means company established under some other acts. Statutory company, company established under some other acts. So maximum paid up share capital and turnover. Okay, maximum paid up share capital 2 crores and maximum turnover 20 crores in the preceding financial year. Maximum 20 crores turnover in the preceding financial year. So the current year status depends on the previous year turnover. Current year status of small company depends on the previous year turnover. Okay, maximum 20 crores in the preceding financial year. And these are not small companies. They will never be small companies irrespective of paid up share capital and turnover. Never be small companies. Never be small companies irrespective of never be small companies irrespective of paid up share capital and turnover. Never be small companies irrespective of paid up share capital and turnover. Okay, they'll never be small companies. So if you look at these words in the examination outrightly, we have to say it is not a small company. Don't. So you go to the paid up share capital and turnover at the end. By looking at the practical question in the exam, identify if you see any of these words in the question. If you look at any of these words, then obviously we have to ignore this. Okay, we no need to look at paid up share capital and turnover. So this will never be small companies irrespective of paid up share capital and turnover. Okay, the small company definition. Next, section 8 company. What is its object? What it was doing? Charitable company or section 8 company. Section 8 company or charitable company, what is their object? Promotion of charity or any other social utility, promotion of sports, education, etc. Promotion of sports, education or any other object of general public utility. Okay, promotion of sports, education, etc. or any other object of general public utility or any other object of general public utility, some charitable object. Some charitable object, any object of general public utility, sports, education, research, religion, etc. Okay, objective. So they should not pay dividend. Prohibition, what is the prohibition? They should not pay any dividend. They should not pay any dividend, no dividend. And application of profits, since they should not pay any dividend and the profit shall be applied only to promote charity, only to promote charitable objects, only to promote charitable objects. So 3 points. With what intention company has started? Company has started with an intention to promote charity. Even though they don't have any intention to earn the profits, but still there may be possibility of getting the profits. Okay, they don't want profits, but they may get profits. That is important. They don't want profits, but they may get profits. Okay, their object is to promote charity, so therefore they don't want profits, but they may get profits, but they may get profits. Okay, they don't want profits, but they may get profits. Okay, right. So that is the reasons. Even though they have incorporated for a charitable purpose, they may get a profits. Sir, why they will get profits if they don't want profits? Donations. Somebody will give donations to the company, and that donations company will put in the bank fixed deposit, and that interest is an income. Okay, and they are constructing one building. They have one building, and they have given that building as a rental basis. Remember, this Section 8 company, they can do any commercial activity like normal companies. The only thing is what they are doing with the profit. That is important. The prohibition is not to earn the profits. The prohibition is application of profits. So you are constructing some building and you are giving a building on rental basis, purely commercial rental, high rental. Section 8 company also can do it. Somebody has donated some land to the Section 8 company. Section 8 company has constructed a building on that land and it has given to all shopping malls. And they are charging high rate of rent, not like normal commercial rent. Absolutely possible. The permitted. What you are doing with the rental income is important. Prohibition is not to earn income. Prohibition is on application of income. Okay, to do the charity I need money. Therefore I am earning money. Earning money is not prohibited. Paying that money, paying that income as dividend to the shareholders is prohibited. I can earn income without any limit. I can do any commercial activity. Whatever the profit I got by that commercial activity, what I will do is the important point. So therefore there is no prohibition that Section 8 company should not do commercial activities. Section 8 company, they can do any commercial activities. They can sell the books, they can conduct programs, and they can charge fees, entrance fees for programs, everything they can do. Whatever the profits they got, what they are doing is important. My intention is to promote the charity. How I can promote the charity? I cannot simply say words to the people, needy people, poor people. I want to do some charity. What I will do the charity? I have to provide food. I am doing charity, but the shopkeeper is not doing charity, right? If I go and ask the shopkeeper, I want to donate some free rice to the poor people, can you give by free of cost? Shopkeeper will not give. I have to pay money to the shopkeeper. Yes or no? So therefore, Section 8 company can do any commercial activity. They can earn any much of income. But the only thing is that income, whatever they are earning, that they should not pay as a dividend to the shareholders. They have to apply to promote the charity. Therefore, without doing commercial activity, you will not get profits. Without doing commercial activity, you will not get profits. So to do charity, I want to distribute clothes, etc. But where I will get it? I have to go to the shop and buy it. Yes or no? That shop owner will not give free of cost. Therefore, without having money, how can I do the charity? Therefore, I can do the commercial activities, but whatever the profits I got, I have to distribute it to the shareholders. Okay, right. Sorry, not distribute to the shareholders. You have to apply the profits to the charitable object. So therefore, they don't want profits, but they may get profits, and they will get profits. They will get profits. Okay, so that is the point. They don't want profits, but they may get profits. But that they should not pay dividend. They should not pay that profits as dividend. They should not pay that profits as dividend. But they should not pay that profits as dividend. But they should not pay that profits as a dividend. But they should not pay that profits as a dividend. They should apply the profits to promote charity. They should apply the profits to promote charity. They should apply the profits to promote charity. They should apply the profits to promote the charity. Okay. So therefore they don't want profits, but they may get profits, but they should not pay that profits as dividend. They should apply the profits to promote charity. That is section 8 company. Next, dormant company, inactive company, producer company. These definitions also will not be there in the CA Inter. So we have to be careful. Dormant company means I got an idea of incorporating a company. Okay, so I have incorporated a company but not doing active business, Okay, so therefore I can apply for a dormant company status, where a company is formed and registered under the act for a future project. Company is formed for a future project. Company is formed for a future project, or to hold an asset or intellectual property and has no significant accounting transaction, or an inactive company may make an application for the obtaining the status of dormant company. Therefore, two sets of dormant companies. Okay, one is inactive companies, another one is inactive companies, other dormant companies. Inactive companies, other dormant companies. Therefore, all inactive companies are dormant companies, but all dormant companies are not inactive companies. Okay, dormant company and inactive company. So other dormant companies, this status is normally voluntary and this status is by compulsion. Okay, all inactive companies are dormant companies, but all dormant companies may not be inactive companies. Okay, right. So we'll see these other dormant companies. What are the conditions to be fulfilled by other dormant companies? Okay. Okay, these other dormant companies, they have to fulfill two conditions. One is future project, or to hold intellectual property rights. Future project or to hold intellectual property rights, plus no significant accounting transaction. No significant accounting transaction. Either I am incorporating a company today, but I am not doing activity now. I'll do activity in future. I want to do business in after 3 years or 5 years. Sir, if you want to do business after 3 years or 5 years, why you have incorporated a company today? I have a plan of doing the active business after 5 years. Then what is the necessity of incorporating a company today? Many reasons. First one is name. Okay, today I got some innovative name like say Jenny VFX. This is one recent company which I have incorporated. That is animation company. Okay, so I got this is a new name we want. JENE VFX. This is our company name. So I want to incorporate a company with this name. Okay, after 5 years, during these 5 years, maybe somebody will get the thought of incorporating a company with the same name. Okay, so therefore I want to utilize that name. That is one reason. Another reason, so in order to do some manufacturing activity, I want factory building, etc. Now the land is available at cheap cost. Maybe after 5 years, land cost may increase. Okay, now I am incorporating a company and purchasing a land. That's it. Okay, I'll do the active business after 5 years. Because of cost constraints, I am purchasing the land now whenever the prices are available. So therefore, I am incorporating a company for doing business in future. I am incorporating a company for doing business in future. Or another possibility is that I will not do business in future. Not in now, not in future also. I'll simply hold intellectual property right. That's it. I'll simply hold intellectual property rights. Normally, these companies are holding companies which will have a brand name or patent, etc. Brand name or patent. The subsidiary company will do active business. Under the brand name of the holding company. Okay, say for example, if you take the Horlicks is a brand name used by the subsidiary company. So the holding company is the owner of this brand name called as Horlicks. Okay, this is a foreign company. So therefore, subsidiary company, normally it happens, subsidiary company uses some brand name like Horlicks or Tata, etc. So Tata is a brand name of holding company. Okay, holding company is the owner of that brand name. Subsidiary company is doing the business with that brand name. Now the subsidiary company will pay royalty to the holding company. This holding company will never do any business. That holding company will never do any business purchase. Not in now, not in future. First category of the dormant companies. Even though at present I am not doing in business, I'll do business in near future. Second category, I'll never do the business. Always in my balance sheet there is only one asset. What is that asset? Brand name or patents, etc. Patents, brand name, etc. So this subsidiary company will do active business by utilizing the brand name of this company, and they will pay royalty. Okay, right. That is what these 2 points. Okay, here formed for a future project, or to hold an asset or intellectual property, or is there. Formed for a future project, or to hold an asset or intellectual property, and has no significant accounting transaction, okay, then this will be a dormant company. Inactive company, all inactive companies are dormant companies. Inactive companies means not filed financial statements during the last 2 financial years. Okay, not filed financial statements during last 2 financial years. Not filed financial statements during last 2 financial years. Inactive company, it is not that they are not doing business. They may be doing business, but they are not filing financial statements during last 2 financial years. So these are the 2 sets of dormant companies. One company which is established for future projects or to hold intellectual property, but they don't have any other significant accounting transaction. Or another set of companies is inactive companies, not filing financial statements for 2 previous years. Next, producer company, as the name itself indicates, it is a company floated for the benefit of farmers, right from the procurement of seeds till the stage of selling the final output. This company will help the farmers. Producer company is a company in which all the farmers are the members. Producers, they are the members. So this company assists the farmers right from the procuring seeds, good quality seeds, predicting the climate, which crop is good this year, how much yield you can expect, and how to enhance the yield, till the marketing of the products. So after getting the crop, they will do segregate as per the quality, and they will do packing and exporting. Okay, this company will help the farmers from the beginning to the end. Okay, that is called as producer company. Primary producers, that is farmers. Okay, agricultural produce. That's all the definitions of companies. Next, one person company will be there. Important definition: one person company. 3 aspects: subscriber, nominee, and director. One subscriber, one nominee, minimum one director. One subscriber, one nominee, minimum one director. Not minimum one subscriber, not minimum one nominee. Only one subscriber, one nominee. But directors, minimum 1, maximum 15. Minimum 1, maximum 15. Okay. And the subscribers and nominee, Indian citizens. The subscribers and nominee, Indian citizens, may be resident or non-resident. Indian citizens, resident or non-resident. Not a minor. Only in one company. The subscribers and nominees, Indian citizen, resident or non-resident, not a minor, only in one company. A person can act as a director of 20 companies. Therefore there is no limit on this director. But these subscribers and nominees who are acting in our company, they should not act in another OPC. Only in one OPC, not one company, right? Only in one OPC. They can become a member in another companies also, private or public. Only in one OPC. Subscriber and nominee, only in one OPC. Residential status, 120 days in the preceding financial year. Resident means minimum 120 days in a preceding financial year. Residential status, minimum 120 days in preceding financial year. Minimum 120 days in preceding financial year. Okay. Change in the nominee. Okay. subscriber changing the nominee, nominee withdrawing consent, nominee withdrawing consent. Okay, either subscriber may change the nominee or nominee may withdraw the consent. Either subscriber change the nominee or nominee may withdraw the consent. If the subscriber changes the nominee, he has to inform the company. He has to inform new nominee to company. He has to inform new nominee to company, and company will file new nominee with ROC. Okay. If the subscriber is changing the nominee, he has to inform a new nominee to the company. Company will file with ROC. If the nominee is withdrawing the consent, he has to inform the subscriber that he was withdrawing the consent, and he has to inform the company. And he has to inform the company that he was withdrawing the consent. In that case also, subscriber will appoint a new nominee, and filing with ROC is common. Okay, so subscriber himself is changing a nominee. In that case, he will inform new nominee to the company, and company will file with ROC. Or if the nominee withdraws consent, these are the two additional points. Nominee will inform the subscriber, subscriber will appoint a new nominee, and nominee also will inform the company that he was withdrawing the consent. So this nominee who becomes a member in the event of death or incapacity of the present member, who will become member in the event of nominee is a person who will become member in the event of death or incapacity. In the event of death or incapacity, not only death but also incapacity of present member. Okay, who will become a member in the event of death or incapacity of a present member. Okay. Next, documents required for incorporation of a company, that is also important. Documents required for incorporation of a company. First one, memorandum and articles. Next, statutory declaration by professional and company director. By outside professional and company director. Memorandum and articles, statutory declaration by outside professional and company director. No conviction declaration by each subscriber and first director. No conviction declaration by each subscriber and director. No conviction declaration by each subscriber and director. Temporary communication address till registered office is established for the company. Temporary communication address till registered office is established for the company. Temporary communication address till registered office is established for the company. Okay. MOA and AOA, statutory declaration by outside professional and company director. Okay, no conviction declaration by each subscriber and each director. Temporary communication address till registered office is established for the company. Okay, next, particulars of subscribers and directors. Such as names, nationality, address, etc. Particulars of subscribers and directors such as names, nationality, address, etc. Next, written consent of directors, written consent of proposed directors, interest of the proposed directors, in other firms or body corporates, interest of proposed directors in other firms or body corporates, interest of proposed directors in other firms or body corporates, interest of proposed directors in other firms or body corporates. Okay, so these are the documents to be submitted for incorporation of a company. Important question and easy to score. Memorandum and articles, statutory declaration by professional and director, no conviction declaration by subscriber and director, temporary communication address, particulars of subscribers and directors such as names, nationality, address, etc., written consent of proposed directors, okay, interest of proposed directors and other firms or body corporates. Next, this is also important. Commencement of business. Immediately after incorporating a company, company cannot commence its business. Requirements to commence business or borrow loans. 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 Okay, requirements to commence business or borrow loans. Filing of verification of registered office. Filing of verification of registered office. Filing of verification of registered office within 30 days of incorporation. Filing of verification of registered office within 30 days of incorporation. Filing of verification of registered office within 30 days of incorporation and filing of declaration that subscribers paid money for the shares subscribed. Okay, filing of declaration that subscribers paid money for the shares subscribed. Okay, filing of declaration that subscribers paid money for the shares subscribed. Okay, filing of declaration that subscribers paid money for the shares subscribed within 180 days of incorporation. 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 Approval from sectoral regulator. Approval from sectoral regulator. Approval from sectoral regulator like RBI, SEBI, etc. Like RBI, SEBI, IRDA, etc. Approval from sectoral regulator. Approval from sectoral regulator. Filing of verification of registered office within 30 days of incorporation. Filing of declaration that subscribers paid money for the shares subscribed within 180 days of incorporation. Approval from sectoral regulators like RBI and SEBI. So after filing these three documents only we can start the business. Even though we got certificate of incorporation, still we cannot start the business unless you file all the three documents. Okay, certificate of incorporation is not sufficient to start the business. Certificate of incorporation is not sufficient to start the business. To commence the business we need to file these three documents. Okay, that is this point. Doctrine of ultra virus is also important. Simple theory question. Okay, ultra means beyond, virus means powers. Ultra means beyond, virus means powers. Ultra virus the company means in excess of the powers of the company. Ultra virus the company means in excess of powers of the company. Ultra virus the company means in excess of powers of the company. Ultra virus the company means in excess of powers of the company. In excess of powers of the company as given in MOA and Companies Act. As given in MOA and Companies Act 2013. Ultra virus the company means in excess of powers of the company as given in MOA and Companies Act 2013. Okay, ultra virus the company means in excess of the powers of the company as given in MOA and Companies Act 2013. Okay, next, ultra virus acts are wide ab initio. Ultra virus acts are wide ab initio. Ultra virus acts are wide ab initio. They cannot be ratified even with the consent of all directors. they cannot be ratified even with the consent of all directors. They cannot be ratified even with the consent of all directors. They cannot be ratified even with the consent of all directors. They cannot be ratified even with the consent of all directors. Okay. Company has a right to retain the property. Company has a right to retain the property acquired in an ultra vires transaction. Company has a right to retain the property. Company has a right to retain the property acquired in an ultra vires transaction. Okay, company has a right to retain the property acquired in an ultra vires transaction because company's money is spent on that. Because company's money is spent on it. Because company's money is spent on it. Okay, company has a right to retain the property acquired in an ultra vires transaction because company's money is spent on it. Because company's money is spent on it. Next, company can recover from directors. Company can recover from directors the loss or damage occurred to it. Company can recover from directors the loss or damage occurred to it. The loss or damage occurred due to ultra vires transaction. Due to ultra vires transaction. Company can recover from directors the loss or damage occurred due to ultra vires transaction. Company can recover from directors the loss or damage occurred due to ultra vires transaction. Okay. If shareholders has any information, if shareholders has any information that directors are proposing an directors are planning an ultra vires transaction. If shareholders has any information that the directors are planning an ultra vires transaction, then they can bring a stay order from the court. Then they can bring a stay order or injunction order from the court. If the shareholders has any information, that directors are planning an ultra vires transaction, then they can bring a stay order or injunction order from the court. Stay order or injunction order from the court. Okay. If shareholders has any information that directors are planning an ultra vires transaction, then they can bring a stay order or injunction order from the court. Okay. This is all about the ultra vires transactions. Signing of memorandum and articles by subscribers. Signing of memorandum and articles by subscribers. Literate individual. So if the subscriber is illiterate, then he can put such a subscriber can put his own signature. Subscriber can put his signature on MOA. Subscriber can put his signature on MOA. Okay. Illiterate person. Okay, illiterate person, thumb impression should be affixed. Illiterate person, thumb impression should be affixed. Illiterate person, thumb impression should be affixed. Illiterate person, thumb impression should be affixed, which should be authenticated by illiterate person, thumb impression should be affixed, which should be authenticated by signature of another literate person, signature of one literate person. Okay. Illiterate, thumb impression should be affixed, which should be authenticated by signature of literate person, which should be authenticated by signature of literate person. Next, body corporate. Next, director, officer or employee. Director or officer or employee authorized by it. Director, officer or employee authorized by it. Director, officer or employee authorized by it, director, officer or employee authorized by it, LLP, partner authorized by LLP, partner authorized by it, okay, LLP partner authorized by it, partner authorized by it, foreign national, foreign national, signature and address should be attested by notarized public. Okay, signature and address, signature and address, signature and address, foreign national, signature and address should be notarized with notary public. Signature and address should be notarized with notary public. Signature and address should be notarized with notary public. Okay, signature and address should be notarized with notary public. So this is how various subscribers can sign on the memorandum. If the subscriber is a literate person, no problem, he can put his signature. If the subscriber is an illiterate person, his thumb impression to be affixed and one literate person should sign. And body corporate, director, officer or employee authorized by body corporate, LLP, partner of LLP can sign on the memorandum. Okay, foreign national, his signature and address should be notarized by notary public. Okay, that is how the memorandum will be signed. Next, effect of memorandum and articles. Once registered, what is the effect of memorandum and articles? Effect of memorandum and articles when after registration. Effect of memorandum and articles once after registration. After registration. Effect of memorandum and articles after registration. Okay, they shall be binding on company and each members. They shall be binding on company and each member. They shall be binding on a company and each member. Each member, that is to say subscriber or subsequent members, subscriber as well as subsequent members, subscribers as well as subsequent members, subscribers as well as subsequent members. They shall be binding on company and each member. Each member means first shareholders and subsequent shareholders. First shareholders is subscribers and subsequent shareholders. Subscribers as well as subsequent members, as if they have been signed by the, as if they have been signed by the, as if they have been signed by the company and each member. As if they have been signed by the company and each member. They shall be binding on company and each member. Each member means subscriber as well as subsequent member, as if they have been signed by the company and each member. As if they have been signed by the company and each member. Okay. Money due from the member to the company. 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 Okay. As per MOA. As per MOA. Money due from the member to the company as per MOA shall be a debt due to the company. Shall be a debt due to the company. Shall be a debt due to the company. Money due from the member to the company as per MOA shall be a debt due to the company. Okay, company can recover such debt. Company can recover such debt. Company can recover such money. Okay, company can recover such money like any other, like any of its receivables, like any other, like any of its receivables. Okay. Company shall recover such money like any of its receivables. Company shall recover money. Company can recover such money like any of its receivables. That means there is no difference between shareholder and debtor. Okay, company supplied goods to A. Okay, and A has to pay money. A is a debtor. A is a debtor. company allotted shares to B. Company allotted shares to B. B is a shareholder. Okay, if B did not pay the call money, the treatment will be same treatment. Okay, same treatment. Other receivables, company sold goods to A. A is a debtor of the company. If A fails to pay the company, how company will recover from A? Similarly, company allotted shares to B. B is a shareholder of the company. If B does not pay the call money, company will use the same methodology of recovery. Okay, same treatment to recover both. That is what this point. Okay, money due from the member to the company as per MOA shall be a debt due to the company. Company can recover such money like any of its receivables. Okay. Alteration of AYA, very simple question. Special resolution to be passed. Central government approval to be obtained only when public company is converted into private company. Central government approval not always. Central government approval to be obtained only when public company is converted into private company. Okay, right. Similarly, okay, conversion of private company to public company. Conversion of private company to public company. Conversion of private company to public company will be effective from the date of alteration of AOA. Okay, conversion of private company to public company will be effective from the date of alteration of AOA. Conversion of private company to public company will be effective from the date of alteration of AOA. From the date of alteration of AOA. Next, conversion of public company to private company. Conversion of public company to private company will be effective only after central government approval is obtained. Will be effective only after central government approval is obtained. Conversion of public company to private company will be effective only after central government approval is obtained. Conversion of public company to private company will be effective only after central government approval is obtained. Copy of special resolution, copy of altered articles, copy of copy of central government order. Okay, copy of special resolution, copy of altered articles, copy of central government order to be filed with ROC. Okay, copy of special resolution, copy of altered articles, copy of central government order to be filed with ROC. Alteration to be noted in every copy. Alteration to be noted in every copy. Alteration to be noted in every copy. Alteration to be noted in every copy by annexure, by annexing or embodied in it. By annexure or embodied in it. Okay, alteration to be noted in every copy by annexure or embodied in it. So this is also expected question. Copy of documents to be given to members. So members may ask the company. What members can ask the company? These 4 documents: memorandum, articles, agreement and resolutions. Members can ask any of these 4 documents to the company. Company has to provide the members within 7 days. within 7 days company has to provide these documents to the company members on payment of the prescribed fees. Okay, members will ask these documents to the company, members will pay fees to the company, company shall provide within 7 days. If the company does not provide within 7 days, then penalty. First step, members will request this. Second step, members has to pay the fees. Third step, company shall provide within 7 days. Fourth step, if company did not provide within 7 days, company has to pay this penalty. Okay. Rectification of name. It occurs when it occurs when it occurs when a registered trademark is infringed. A registered trademark is infringed. It occurs when a registered trademark is infringed, or the name of a company. It occurs when a registered trademark is infringed, or the name of a company is identical or similar to the name of another company. It occurs when a registered trademark is infringed, or the name of a company is identical or similar with the name of another company. Identical or similar with the name of another company. Identical or similar with the name of another company. Okay, it occurs when a registered trademark is infringed, or the name of a company is identical or similar with the name of another company. Owner of registered trademark. Owner of registered trademark. Owner of registered trademark. Owner of registered trademark shall file an application to the central government. Owner of registered trademark shall file an application to the central government. Owner of registered trademark shall file an application to the central government. Okay, within 3 years. Within 3 years of incorporation of within 3 years of incorporation of such infringing company. Within 3 years of incorporation of such infringing company, owner of registered trademark shall file an application to the central government within 3 years of incorporation of such infringing company. Okay, infringing company. Within 3 years of incorporation of such infringing company, central government shall give direction to the company. Central government shall give a direction to the company. Central government shall give a direction to the company. Company shall alter its name. Company shall change its name. Company shall change its name. Company, central government shall give a direction to the company. Company shall change its name within 3 months of central government order. Within 3 months of central government direction by passing ordinary resolution. Within 3 months by passing ordinary resolution. Okay, company shall change its name within 3 months of central government order by passing ordinary resolution. Company shall file with ROC. Company shall file the required documents 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 with ROC. If company fails to change its name, if company fails to change its name, if company fails to change its name, then central government itself may allot one name. Then central government itself may allot a name to the company. Okay, if company fails to change its name, then central government itself may allot a name to the company. May allot a name to the company. If company fails to change its name, then central government itself may allot a name to the company. This is an amendment. It is applicable to your exam. The central government itself may allot a name to the company. Such name is as follows, is structured as under. Such name is structured as follows. Such name is structured as follows. Okay. ORDNC, year of central government direction, serial number, year of central government direction, serial number, existing SIN of the company, existing corporate identity number of the company. Okay. ORDNC, year of central government direction, serial number, existing corporate identity number of the company. So this ORDNC means order of regional director not complied. Order of regional director not complied. Order of regional director not complied. ORDNC means order of regional director not complied. Year of central government directives, serial number, existing SIN of the company. So this is how the central government will allot a new name to the company. If the company fails to change its name, central government will allot a new name in this manner. Okay. So subsidiary company not to become a member of holding company. General rule: in case of holding company having share capital, subsidiary company shall not acquire any shares in it. Subsidiary company shall not acquire any shares in holding company. Subsidiary company shall not acquire any shares in holding company. In case holding company not having share capital, subsidiary company shall not acquire any membership in shall not acquire any other membership interest in the company. Any other membership interest in the holding company. Any other membership interest in the holding company. General rule: holding company not, if the holding company is having share capital, subsidiary company shall not acquire any shares in the holding company. If the holding company is not having share capital, then subsidiary company shall not acquire any other membership interest in the holding company. Any other membership interest in the holding company. Next, exceptions. Legal representative of a deceased member. Okay, as a legal representative of a deceased member, as a legal representative of a deceased member, as a legal representative of a deceased member, as a trustee, as a legal representative of a deceased member, as a trustee before becoming subsidiary. Before becoming a subsidiary. Okay, as a legal representative of a deceased member, as a trustee before becoming a subsidiary. as a legal representative, a decision member, as a trustee before becoming a subsidiary. In these two cases, voting rights will be given. In these two cases, voting rights will be given. In these two cases, voting rights will be given. Before becoming a subsidiary, voting rights will not be given. Voting rights will not be given. Okay. General rule, they should not hold any shares and they should not hold any membership interest. For that, 3 exceptions: legal representative, trustee before becoming a subsidiary. So voting rights will be given in the first 2 cases and voting rights will not be given in the third case. In the third case, voting rights will not be given. So this is a company which is already doing charitable activities but not registered under Section 8. Now they are applying for registration or license under Section 8. Existing charitable company. Conversion of not existing profit motive to charitable. Already the company is charitable company without license under Section 8. They are doing charity but they have not obtained license under Section 8. They are doing as a normal company. Okay, so therefore existing charitable company to Section 8 charitable company. Okay, if a company incorporated under Companies Act, if a company incorporated under Companies Act is doing same charitable objects, if a company incorporated under Companies Act is doing same charitable objects as given under Section 8, okay, if a company incorporated under Companies Act is doing same charitable objects as given under Section 8, but without license under Section 8, okay, if a company incorporated under Companies Act is doing charitable objects as given under Section 8, but without license under Section 8, then it can make an application to ROC. Then it can apply to ROC. Okay, for obtaining license. License under Section 8. Then it can apply to ROC for obtaining license under Section 8. Okay. If a company incorporated under Companies Act is doing same charitable objects as under Section 8 but without license under Section 8, it can apply to ROC for obtaining a license under Section 8. Okay, right. So following documents should be submitted. Memorandum and articles, declaration by professional, that memorandum and articles is prepared as per the provisions of Companies Act. Declaration by professional that memorandum and articles is in compliance with the requirements of Section requirements of Section 8. Okay, memorandum and articles, declaration by professional that MOA and AOA is in compliance with the requirements of Section 8. Memorandum and AOA is in compliance with the requirements of Section 8. Okay, next, financial statements of last 2 years. financial statements of last 2 years, financial statements of last 2 years, last two complete years, value of assets and liabilities, value of assets and liabilities, value of assets and liabilities, not more than 30 days, not more than 30 days prior to the date of application. Financial statements of last 2 years, value of assets and liabilities, not more than 30 days prior to the date of application, not more than 30 days prior to the date of application. Estimated income and expenditure for the next 3 years, estimated income and expenditure, estimated income and expenditure for the next 3 years, estimated income and expenditure for the next 3 years, estimated income and expenditure for the next 3 years, estimated income and expenditure for the next 3 years. Okay, copy of general resolutions passed at, copy of resolutions passed at general meeting and at board meeting, copy of resolutions passed at board meeting and general meeting. Copy of resolutions passed at board meeting and general meeting. Those are the documents to be filed. Okay, an advertisement to be given in the newspaper. Okay, a notice shall be published in the newspaper. 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 No objection to be obtained from, no objection to be obtained from sectoral regulators. 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 Okay, ROC may issue a license. ROC may issue a license under section 8. ROC may issue a license under section 8. Okay, conditions of license, conditions of license, conditions of license shall be inserted in MOA or AOA or partly in both. Okay, conditions of license shall be inserted in MOA or AOA or partly in both. Conditions of license shall be inserted in MOA, AOA or partly in both. So this is conversion of existing charitable companies. Already they are doing charity, but they are not aware of the provisions of section 8 company. They are not aware of the provisions of section 8 company. Therefore, without license under section 8, they are doing the charitable activities. Now we are obtaining license under section 8. The business is same, but with license and without license. Okay. So in the following three cases, license given under section 8 will be cancelled. Revocation of license under section 8. If section 8 object, these are the three reasons why the license will be cancelled. Either section 8 objects are violated, or license conditions are violated, or fraudulent conduct. If any of these three cases, in any of these three cases, license will be cancelled. Or so if any of these three violations, license will be cancelled. So consequences of license: amalgamation or winding up. Central government may order the company to amalgamate with another section 8 company. Central government may order the company to amalgamate with another section 8 company. Section 8 company. Central government may order the company to amalgamate with another section 8 company. Okay. Next, central government may order the company to wind up. Okay, central government may order the company to wind up. Central government may order the company to wind up. Okay. Surplus assets on the date of winding up. Surplus assets on the date of winding up. Surplus assets on the date of winding up. Surplus assets on the date of winding up shall be transferred to. Surplus assets on the date of winding up shall be transferred to another section 8 company. Another section 8 company with similar objects. Another section 8 company with similar objects. Okay. Company may central government may order the company to wind up. Surplus assets on the date of winding up shall be transferred to another section 8 company with similar objects, or shall be transferred to insolvency and bankruptcy fund. Or shall be transferred to insolvency and bankruptcy fund. That is IBC, insolvency and bankruptcy code. Okay, to revive the insolvency companies. To revive the insolvent companies, that surplus assets will be used. Insolvency and bankruptcy fund. Okay, established under IBC 2016. Established under IBC 2016. Established under IBC 2016. Okay, established under IBC 2016. Okay, this is the revocation of license. Three reasons why the license is revoked. Thereafter, two consequences: either amalgamation or winding up. The simple process, conversion of OPC into public company or private company. OPC can be converted into public company also. Okay. conversion of OPC into public company or private company. So first they have to pass a resolution under section 122. Memorandum and articles to be altered. Number of members to be increased to 7. If OPC to private company, number of members will be 2. If OPC to public company, number of members will be 7. Number of directors to be increased. Number of directors to be increased. If OPC to public company, if OPC to private company, 2 directors. OPC to public company, 3 directors. Okay. So resolution to be passed, memorandum and articles to be altered, number of members to be increased, and number of directors to be increased. Number of directors to be increased. So application to ROC along with the documents. Application to ROC along with following documents. Application to ROC along with following documents. Application to ROC along with following documents. Altered MOA and AOA. Application to ROC along with following documents. Altered MOA and AOA. Resolutions passed. Next, resolutions passed. List of proposed members and directors. List of proposed members and directors. Latest audited financial statements. Okay, list of creditors. List of creditors. List of proposed members and directors. List of creditors. Latest audited financial statements. Latest audited financial statements. Application to ROC along with the following documents. Altered MOA and AOA. Resolutions. List of proposed members and directors. List of creditors and latest audited financial statements. Okay. So ROC may convert the company. Okay. ROC shall approve the firm and issue the certificate. ROC may issue a certificate. ROC may issue a certificate. This is a OPC to public and private company. OPC to public and private company. This is an outdated procedure, old procedure. Because if you observe, there is the entire provision is amended. The red color means entire provision is amended from 2021, April 2021. Therefore, it is applicable to the exam. Amended provision. Next, private to OPC, not public to OPC, private to OPC. Conversion of private company to OPC. Special resolution to be passed. Consent to be obtained from members and directors. Consent to be obtained from members and creditors. 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 Special resolution to be filed with ROC. Application for conversion to be filed along with the following documents. Application for conversion to be filed along with following documents. Along with following documents. Application for conversion to be filed along with following documents. Along with following documents. list of members and creditors, list of members and creditors, declaration by directors that members and creditors have given their consent, declaration by directors that members and creditors have given their consent, okay, list of members and creditors, declaration by directors that members and creditors have given their consent, copy of no objection certificate, no objection from secured creditor, copy of no objection from secured creditor, copy of no objection from secured creditors, copy of no objection from secured creditors, latest audited financial statements, latest audited financial statements. Okay, these are the documents to be filed. Application for conversion to be filed along with the following documents: list of members and creditors, declaration by directors that members and creditors have given their consent, copy of no objection from secured creditors, latest audited financial statements. Latest audited financial statements. ROC may issue a certificate as a OPC. ROC may issue a certificate. ROC may issue a certificate. ROC may issue a certificate. Okay. So these are the conversion. Two conversions. Conversion from public to OPC. Sorry, conversion from OPC into public or private, or similarly conversion of private company to OPC. Okay, right. So we'll take a break for half an hour. Then we'll start. Next, documents to be submitted in support of the registered office address. Documents to be submitted as an evidence of registered office address. As an evidence of a registered office address. Okay. Documents to be submitted as an evidence of a registered office address. Documents of title. Documents of title if the address is company owned premises. Documents of title if the address is company's own premises. Documents of title if the address is company's own premises. Documents of title if the address is company's own premises. Lease or rental agreement. Lease or rental agreement if the address is rental premises, rental building. Okay, document of title if the address is company's own premises. Lease or rental agreement if the address is a rental building. Next, rent receipt. Rent receipt of not older than 1 month. Rent receipt of not older than 1 month. Rent receipt of not older than 1 month. Next, utility bill like gas, telephone, electricity, not older than 2 months. Okay. Gas, electricity or telephone bill. Gas, electricity or telephone bill. Gas, electricity or telephone bill of not older than 2 months. Not older than 2 months. Okay. Not older than 2 months. So these are the documents to be submitted as an evidence that company's registered office is located in a particular place. Okay. As an evidence of registered office address. Very important question. Practically also in your articleship also they will ask the interview question, this one. Most frequently tested interview question. What are the documents to be submitted as evidence of a company's registered office premises? If it is a own building, documents of title like sale deed, ownership document. Rental building, rental agreement, rent receipt not older than 1 month. Gas or electricity bill not older than 2 months. Next, shifting of registered office from one ROC to another ROC within same state. Shifting of registered office. Shifting of registered office from one ROC to another ROC within same state. Within same state. Shifting of registered office from one ROC to another ROC within same state. Shifting of registered office from one ROC to another ROC within same state. Okay. Board resolution, special resolution, board resolution, special resolution, intimation to Chief Secretary of the state, intimation to Chief Secretary of the state, board resolution, special resolution, intimation to Chief Secretary of the state. Okay, intimation to Chief Secretary of the state, application to regional director, application to regional director along with the following documents, application to regional director along with the following documents, application to regional director along with following documents, declaration relating to no outstanding dues to workmen, declaration relating to no outstanding dues, declaration relating to no outstanding dues to workmen, declaration relating to no outstanding dues to workmen. Next, declaration that transfer of pending cases will not be asked. Declaration that company will not ask for transfer of pending cases. Declaration that company will not ask for transfer of pending cases. Declaration that company will not ask for transfer of pending cases. Okay, declaration that company will not ask for transfer of pending cases. Acknowledged copy, acknowledgement of intimation given to Chief Secretary of the state, acknowledgement of intimation given to Chief Secretary of state. Okay, acknowledgement of intimation given to Chief Secretary, acknowledgement of intimation given to Chief Secretary. Okay, declaration that company will not ask for transfer of pending cases, acknowledgement of intimation given to Chief Secretary of the state, acknowledgement of intimation given to Chief Secretary of the state. Next, an advertisement in newspaper, an advertisement in two newspapers, an advertisement in two newspapers at least 14 days before the date of hearing, at least 14 days before the date of hearing. So this is where the students are confusing. This advertisement should be made not before application to regional director. First we have to make an application to regional director. Thereafter regional director will give something called as a date of hearing. Okay, when we file an application, it is not that regional director is sitting idle and immediately he will read the application and discuss. No, he will give an appointment date. We are filing an application to regional director, say today 2nd December. If we file an application to the regional director will say, okay, come 20th December or come 1st January. He will give an appointment date. It's not that he was idle and immediately he will discuss with our application. So he will give some appointment date. That appointment date is called date of hearing. to that date 14 days, oh sorry, 14 days or 2 weeks before we have to give an advertisement, not before the application, not before the application. Okay, so first we have to file an application to the regional director, and after filing an application he will give something called as date of hearing, also known as appointment date. Okay, application and appointment date, at least 14 days before the date of hearing, at least 14 days before the date of hearing we have to give an advertisement in the newspaper. So thereafter regional director will consider the objections if any. Okay, regional director will consider the objections if any, okay, from the creditors. Regional director shall give confirmation, regional director shall give confirmation within 30 days of application. Regional director shall give confirmation within 30 days of application. Regional director shall give confirmation within 30 days of application. Company shall file such confirmation with ROC. Company shall file such confirmation with ROC. Company shall file such confirmation with ROC within 60 days. Company shall file confirmation with ROC within 60 days. And ROC will give certificate within 30 days of filing. ROC will give certificate within 30 days of filing. ROC will give certificate. Okay, ROC will give certificate within 30 days of filing. ROC will give certificate within 30 days of filing. Okay, within 30 days of filing ROC will give certificate. This is the overall procedure. Next, dematerialization, also important topic. Dematerialization or demat shares. Dematerialization. Okay, dematerialization. Every company making public offer, every company making public offer shall issue securities only in demat form. Okay, every company making public offer shall issue securities only in demat form. Every company making public offer shall issue securities only in demat form. Public offer demat mandatory. Public offer demat mandatory. Every company making public offer shall issue securities only in demat form. Okay, so before public offer, all the convertible securities held by promoters, before public offer, all the convertible securities held by promoters, before public offer, all the convertible securities held by promoters in physical form, held by promoters in physical form, shall be converted into demat form. Shall be converted into demat form. Okay, before public offer, all the convertible securities held by promoters in physical form shall be converted into demat form. Okay, before public offer, all the convertible securities held by promoters in physical form shall be converted into demat form. Shall be converted into demat form. Okay, other companies may convert their may convert their existing securities. Other companies may convert their existing securities into demat form. Other companies may convert their existing securities into demat form. other companies may convert their existing securities into demat form, may issue new securities in physical form or demat form. It may issue new securities in a physical form or demat form. Okay, other companies may convert their existing securities into demat form, issue new securities in physical form or demat form. This is may. Okay, company making public offer. In case of company making public offer, it is shall. Mandatory conversion shall be converted into demat form. Other companies, it is may. They can also use the demat form, but that is optional. That's it. Other companies also can use the demat form, but that is optional. Convert their existing securities into demat form or in physical form. Issue new securities in physical form or demat form. Right. Shelf prospectus, red herring prospectus, also very important topics. Okay. Shelf prospectus valid for not more than 1 year. Shelf prospectus valid for not more than 1 year. Shelf prospectus valid for not more than 1 year. Validity starts from the date of opening of the first offer. Validity starts from the date of opening of first offer. Validity starts from the date of opening of first offer. Shelf prospectus is valid for not more than 1 year. Shelf prospectus is valid for not more than 1 year, not fixed 1 year. You can fix it as a 3 months or 6 months or 8 months, 9 months, etc. Maximum 1 year. Act says maximum 1 year. You can impose 6 months also. My shelf prospectus is valid for 6 months, 8 months. Your choice. Act says it is 1 year. Okay, this is important for fill in the blanks. Valid for not more than 1 year. Shelf prospectus valid for not more than 1 year. And from where the validity starts? Validity starts from the date of opening of the first offer. This is also true or false or fill in the blank. Starts from the date of not filing with ROC, not filing with SEBI, etc. They will give the options from the date of opening of the first offer. Validity starts from the date of the opening of the first offer. Okay, shelf prospectus is issued only for first offer. Shelf prospectus is issued only at the time of first offer during its validity period. Shelf prospectus is issued only at the time of first offer during its validity period. Shelf prospectus is issued only at the time of first offer during its validity period. Shelf prospectus is issued only at the time of first offer during its validity period. Okay, for subsequent offers during its validity period, for subsequent offers, information memorandum shall be issued. Okay, for subsequent offers, information memorandum will be issued. For subsequent offers, information memorandum shall be issued. For subsequent offers, information memorandum shall be issued. Okay, information memorandum contains changes between two offers. 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 Okay, right. So after reading the changes, after reading such changes, if any person wants to withdraw his application, after reading such changes, if any person wants to withdraw his application, if any person wants to withdraw his application, after reading such changes, if any person wants to withdraw his application, then company shall refund his money within 15 days. Then company shall refund his money within 15 days. After reading such changes, if any person wants to withdraw his application, then company shall refund his money within 15 days. So therefore, before this change, before knowing these changes, if any person has given advance money to the company, before these changes, if any person has given advance money to the company, now that person, after knowing about these changes, he may wants to cancel his application. Company should allow cancellation and refund the money within 15 days. Okay. Shelf prospectus can be issued only by companies prescribed by SEBI. Shelf prospectus can be issued only by companies prescribed by SEBI. Shelf prospectus can be issued only by companies prescribed by SEBI, and that also only for debt securities. Shelf prospectus can be issued only by companies prescribed by SEBI, and that also only for debt securities like debentures or bonds, and that also only for debt securities like debentures and bonds, not for equity shares. Shelf prospectus cannot be used for equity shares or preference shares. It is used only for debentures or bonds. Shelf prospectus can be issued only by companies prescribed by SEBI, and that also only for debt securities like debentures or bonds. Debt securities like debentures or bonds. Information memorandum to be filed with ROC. Information memorandum to be filed with ROC. Information memorandum to be filed with ROC at least 1 month prior to subsequent offer. At least 1 month prior to subsequent offer. Information memorandum to be filed with ROC at least 1 month prior to subsequent offer. At least 1 month prior to subsequent offer. Shelf prospectus plus information memorandum together is called complete prospectus. Together is called full-fledged prospectus. Together is called complete set of prospectus. Okay, together is called complete set of prospectus. Shelf prospectus plus information memorandum together is called complete set of prospectus. So this concept is also very important, either as a theory question or true or false and MCQs. Shelf prospectus question. Red herring prospectus. Red herring prospectus. Red herring prospectus. It does not, it is an incomplete prospectus. It is an incomplete prospectus. It is an incomplete prospectus and does not include, it is an incomplete prospectus and does not include number of securities offered and the issue price. It is an incomplete prospectus and does not include number of securities offered and issue price. Number of securities offered and issue price. Okay. Red herring prospectus shall be issued to public. Red herring prospectus shall be issued to public after 3 days from filing with ROC. After 3 days from filing with ROC. Red herring prospectus shall be issued to public after 3 days from filing with ROC, but before 90 days. Red herring prospectus shall be issued to public after 3 days from filing with ROC, but before 90 days. But before 90 days. Okay. But before 90 days. After closing the issue. After closing the issue. After closing the issue. Company has to file final and complete prospectus. After closing the issue, company has to file. After closing the issue, company has to file final and complete prospectus with ROC. After closing the issue, company has to file final and complete prospectus with ROC. Prospectus with ROC. After closing the issue, company has to file final and complete prospectus with ROC. Next, the differences between red herring prospectus and final prospectus should be highlighted. Differences between red herring prospectus and final prospectus. Differences between red herring prospectus and final prospectus shall be highlighted as variations. Okay, differences between red herring prospectus and final prospectus shall be highlighted as variations. Differences between rendering prospectus and final prospectus shall be highlighted as variations. Okay, so that ROC can easily identify what is missing in the original rendering prospectus, whether all such information is given in the final prospectus or not. So in order to ensure that public offer is not delayed, in order to ensure that public offer does not get delayed, you can start the public offer with whatever the information you have. So as per the SEBI guidelines, we need to give detailed information in the prospectus. If all such information is not available, almost 80 to 90% of the information is available, 5 to 10% is not available. Rather than waiting for that 5 to 10% information, go ahead with the public issue and issue the rendering prospectus, pending that 5 to 10% of the information. After closing the public offer, meantime you can obtain that information and include in the final prospectus. So the only point is that, so just because one or two information company is unable to obtain, we don't want to postpone or delay the public offer. Therefore, without that information, incomplete prospectus also we can issue. But after closing the issue, we have to file the final prospectus with ROC. Okay, right? The difference between rendering and final prospectus shall be highlighted. So this is only to ensure that company is not postponing its public offer just because one or two information. Just because one or two information, company is not delaying its public offer. Okay, that is the rendering prospectus. Next, public offer allotment essential conditions. Essential conditions for valid allotment. Essential conditions for allotment. Essential conditions for allotment. Minimum subscription. Minimum subscription as stated in the prospectus. Minimum subscription, Companies Act says whatever stated in the prospectus. Whatever stated in the prospectus. Companies Act says whatever stated in the prospectus is minimum subscription. SEBI regulation says 90% of net offer to the public. 90% of net offer to the public. That means total issue size minus reservations. Total issue size minus reservations. Total issue size minus reservations. Reservations for promoters and employees, etc. In every public offer, at least 20% should be given for promoters, that is minimum promoter subscription, and 5% should be given for the employees. The balance only goes to the public. That means if the company wants to issue 1 crore shares, public will get only 75 lakh shares. 20 lakh shares are dedicated to the promoters and 5 lakh shares are dedicated to employees. That's 75 lakhs into 90% you have to apply. 90% not on entire 1 crore shares, 90% of 75 lakhs. That is 90% of net offer to the public. 90% of net offer to the public. That is as per the SEBI regulations. Next, minimum application amount. Minimum application as per Companies Act 2013, 5% of face value. As per Companies Act 2013, 5% of face value. Minimum application as per Companies Act 2013, 5% of face value. As per SEBI regulations, per share 25% of issue price. Per share 25% of issue price. Per share 25% of issue price. So total per application, total amount per application. Total amount per application 15,000, minimum 15,000. Total amount per application minimum 15,000. Okay, so per share 25% of issue price and total application amount is minimum 15,000. Say for example, face value of the share is 10 rupees, issue price is 1000 rupees. Assume issue price is 1000 rupees. If I want to purchase one share by paying 250 rupees. Okay, issue price is 1000, so 25% of issue price. I cannot purchase one share by paying 250 rupees. I have to pay 250 rupees per share, and in total I have to pay at least 15,000. Each person who applied in the public offer has to pay minimum 15,000. It's not that he will purchase 2 or 3 shares and will pay 500 rupees per share. It is okay. Per share 25% of issue price. Okay, issue price is 1000, per share 25%. So you cannot purchase only one share by paying 250. Minimum 15,000. Minimum 15,000 worth you have to invest in the public offer. Minimum. Okay, right. That is what the point. So minimum application as per Companies Act 5% of face value. SEBI regulations, both limits are there, per share and also total amount of application. Per share and also total amount of application. Next, minimum number of allottees. Minimum number of allottees. Minimum number of allottees. Companies Act no restriction. Minimum number of allottees as per Companies Act no restriction. As per Companies Act no restriction. I want 10 crores. I can collect 10 crores from 5 people or 100 people also. I want 10 crores, I can collect the 10 crores either from 5 people or 20 people or 80 people. But SEBI regulation says at least if 1000 persons have applied, irrespective of how much each person has applied, at least if 1000 people or 1000 persons has applied, then only can go for the public offer. Therefore, SEBI regulations 1000. Okay, minimum 1000 allottees. Entire 100 crores company's money is paid by 50 people or 200 people. Company cannot make the allotment. Company wants 100 crores, 200 people, big investors together invested 100 crores. Still the public company cannot make public offer. Company wants minimum 1000 allottees. That is to say wider participation. Public offer means wider participation. Wider participation means more number of people should apply. Collecting more money is not sufficient. You can collect less amount also. Public offer indicates you have to collect money from more people. Maybe you are collecting less money. It's not that public offer indicates more money or less money. Public offer means more people. Public offer means more people, not more amount. So therefore, just because I have collected 100 crores, it doesn't make a public offer. If I have collected 100 crores from 200 people or 300 people, at least minimum 1000 people I have to collect. So public offer means offer to more people, not raising just more money. Public offer means offer to more people, not just raising more money. This is minimum number of allottees. Basically these reasons: minimum subscription, minimum application, minimum number of allottees. If all the above conditions are satisfied, 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 then securities to be allotted. If all the above conditions are satisfied, then securities to be allotted, and return of allotment to be filed with ROC. Okay, if all the above conditions are satisfied, the securities to be allotted and return of allotment to be filed with ROC in form number PAS3. That form number is also important. In form number PAS3. The form is prescribed under Prospectus and Allotment of Securities Rules. PAS short form for Prospectus and Allotment of Securities Rules. So it's a key to identify in which rules that form is given. It's a key to identify in which rules that form is given. Prospectus and Allotment of Securities Rules. Okay. If all the above conditions are satisfied, the securities to be allotted and return of allotment to be filed with ROC in form number PAS3 within 30 days of allotment. 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 Within 30 days of allotment, along with the following documents. Along with the following documents. Along with the following documents. Okay. Along with the following documents. In case of bonus issue, in case you'll write a separate question, otherwise you'll confuse, because it's a public offer we are writing, right? So I'll strike off this point. along with the following documents, because the documents are for various offers, whereas this is we are writing only for public offer. Above we are writing only for public offer. Better rather than clubbing, we'll write a separate question for that. Okay, with the 30 days of allotment. That's it. Okay, 30 days of allotment. So we'll write a separate question for return of allotment. Return of allotment. Return of allotment. Form number PAS3. Okay, to whom it has to be filed? Not to SEBI, etc. To ROC. When to file? When to file? Form number PAS3. When to file? When to file is important. Public offer, private placement. Public offer 30 days of allotment. Private placement 15 days of allotment. Private form number is same, authority is same. Okay, return of allotment, form number PAS3, to whom we have to file that? To ROC only. In case of public offer also. Don't in examination they may trap you by saying that public offer we have to file with SEBI and private placement we have to file with ROC. No. All documents we are filing with ROC only. Shelf prospectus, information memorandum, red herring prospectus, all documents you are filing with ROC only. Okay, right. So therefore, for return of allotment, this is filed with ROC only, both in case of public offer and private placement. But time limits is different. Public offer we have to file within 30 days, private placement within 15 days. Okay. So form number PS3 with ROC within these time limits, and attachments. And attachments. So what are the documents to be attached in case of bonus issue? In case of bonus issue, ordinary resolution passed in general meeting. Ordinary resolution passed at general meeting to be filed. Attachments, what are the documents to be attached to the return of allotment? In case of bonus issue, ordinary resolution passed at general meeting. In case of consideration other than cash, in case of consideration other than cash, in case of consideration other than cash, valuation of shares. Okay, valuation of consideration. Valuation of shares, valuation of consideration, valuation of shares, valuation of consideration. Okay, contract between company and allottees, contract between company and allottees, contract between company and allottees. In case shares are allotted for consideration other than cash, if shares are allotted for consideration other than cash, we have to attach valuation of shares, valuation of consideration, and contract between company and allotment. Okay. List of allottees to be filed in every case. List of allottees. List of allottees to be filed in every case. List of allottees to be filed in every case. List of allottees to be filed in every case. List of allottees to be filed in every case. Whether it is in every case means cash consideration, non-cash consideration, no consideration. In every case means cash, non-cash, and no consideration. Cash, non-cash, and no consideration. Non-cash already we have said, no consideration is nothing but bonus issue only. Whether we have received cash consideration or non-cash consideration, or you have not received any consideration at all. So in all the cases, list of allottees to be filed in every case. 3 cases: cash consideration, non-cash consideration, and no consideration at all. That is bonus shares. Okay, this is the return of allotment. Underwriting commission also important question. Multiple times this topic is tested. It is to be paid only on securities offered to the public. That means not payable for promoters or shares and reservations. So to be paid on security, only on securities offered to the public. That means whatever the reservations are there on this, we should not pay any underwriting commission. To be paid only on securities offered to the public. So what is the rate for shares? 5% or articles of association, whichever is lower. For debentures, 2.5% or articles of association, whichever is lower. Okay, shares 5% or articles, whichever is lower. Debentures 2.5% or articles, whichever is lower. Whichever is lower. So disclosures in prospectus relating to underwriting commission. What are the disclosures to be given in prospectus? Disclosures in prospectus: names of underwriters, rate of commission, number of securities underwritten. Names, rate of commission, number of securities. Okay, so disclosures in prospectus. In the prospectus, we have to disclose these three details: names of underwriters, rate of commission, and number of securities underwritten. Not number of securities subscribed, number of securities underwritten. Underwritten means agreed to be subscribed, not actually subscribed. How much shares underwriters are ready to purchase, but how much shares actually they have purchased depends on the public offer. With the base, whatever the balance left over not subscribed to the public, that only they can purchase. That is actual purchase. But how much shares they agreed to purchase, that is underwritten. Okay, underwritten means number of shares agreed to purchase, not actually purchased. Number of shares agreed to purchased, not actually purchased. They are ready to purchase 80,000 shares. They are ready to purchase 80,000 shares, but actually they have purchased only 20,000 shares. Why, sir? If they are ready to purchase 80,000 shares, why they have purchased only 20,000? Very simple. Public has subscribed to 60,000. Since public has subscribed 60,000, they are purchasing only 20,000. If public subscribes 50,000, they will purchase 30,000. But they are ready to purchase 80,000. So here we have to write 80, not 20 or 30 or 60. That will be known after closing the public offer. Okay, they are ready to purchase up to this many shares. They are ready to purchase up to this many shares. Disclosure in prospectus, filing with ROC. Filing with ROC. Underwriting contract to be filed with ROC along with the prospectus. Underwriting contract to be filed with ROC. Underwriting contract to be filed with ROC along with prospectus. Underwriting contract to be filed with ROC along with prospectus. Underwriting contract to be filed with ROC along with prospectus. We have to attach this document. Underwriting contract to be filed with ROC along with prospectus. Next, after closing the issue, will pay underwriting commission. After closing the issue, will pay underwriting commission. Okay, sources for payment of commission. Sources for payment of commission. Sources for payment of commission: existing profits. Sources for payment of commission: existing profits or proceeds from new issue. Or proceeds from a new issue. Proceeds in the sense amount collected from new issue. Okay, sources for payment of commission: existing profits or proceeds from new issue. Existing profits or proceeds from a new issue. Before public offer, if you are already having existing profits, you can utilize that. So if you don't have any cash before public offer, whatever the public offer we are issuing, from that cash you can utilize. Okay, sources for payment of commission. Next mode of payment of commission. Mode of payment in cash or kind. Mode of payment cash or kind. Mode of payment cash or kind. You can pay underwriting commission either in the form of cash or in form of kind, like goods also. Equity shares with differential rights. Only issue of new shares, no conversion of existing shares. Only issue of new shares, no conversion of existing shares. No conversion of existing shares. Only issue of new shares, no conversion of existing shares. Next, except dividend and voting rights, except dividend and voting rights, all other rights are same, except dividend and voting rights, all other rights are same, like other equity shares. Except dividend and voting rights, except dividend and voting rights, all other rights are same like other equity shares. Okay. Authorization in articles, AOA in articles, ordinary resolution at general meeting or postal ballot, authorization in articles of association, ordinary resolution at general meeting or postal ballot, ordinary resolution at general meeting or postal ballot, maximum 74% of total voting power, maximum 74% of total voting power, maximum 74% of total voting power, at least 5 years to be completed, at least 5 years to be completed, at least 5 years to be completed from the end of financial year, at least 5 years to be completed from the end of financial year in which default, if any, at least 5 years to be completed from the end of financial year in which default, if any, with respect to term loan, with respect to term loan, with respect to term loan is rectified or remedied, is rectified, is rectified. Okay, at least 5 years to be completed from the end of financial year in which default, if any, with respect to term loan is rectified, minimum 5 years after completion of 5 years. Details to be entered in the register of members, details to be entered in the register of members, details to be entered in the register of members. Next, details to be disclosed in the board report, details to be disclosed in the board report, details to be disclosed in the board report. After issue of equity shares with differential rights, details to be entered in the register of members and details to be disclosed in the board report. So what we are discussing is equity shares with differential rights, equity shares with differential rights. So there is a difference, equity shares with differential rights. Sir, what is this difference? Either more dividend with less voting rights or less dividend with more voting rights. That is the difference. With respect, compared to other shareholders, you are getting more dividend and less voting rights, or compared to other shareholders, you are getting less dividend and more voting rights. This less or more to what? Compared to what? This less or more compared to normal equity shares. Less or more compared to normal equity shares. Less dividend with what? Less dividend compared to normal equity shares. Okay, less or more compared to normal equity shares. Okay, so equity shares with differential rights, either you are getting more dividend with less voting rights or more voting rights with less dividend. So this more or less is compared with the normal equity shares. So this you can issue equity shares with differential rights, maximum 74%. Maximum 74% of total voting power. Only we have to issue new shares. We cannot convert equity shares with normal rights and equity shares with differential rights. Vice versa, conversion is not possible. Equity shares with normal rights, equity shares with differential rights. Okay, so these conversions are not permitted. These conversions are not permitted. Company has to issue equity shares with normal rights to some shareholders and company has to issue equity shares with differential rights to some other shareholders. Thereafter conversions is not possible. Thereafter, conversions is not possible. Company has to issue directly. Company has to issue directly equity shares with normal rights to certain shareholders and equity shares with differential rights to certain other shareholders. That is the point. Equity shares with normal rights and equity shares with differential rights. Only company has to issue directly. There cannot be conversions from one kind to another kind. Thereafter, sweat equity shares is also important. Sweat equity shares issued to directors or employees, issued to directors or employees because they have provided. It is sweat equity shares are issued to directors or employees because they have provided know-how or intellectual property rights to the company. Okay, sweat equity shares are issued to directors or employees because they have provided know-how or intellectual property rights to the company. Know-how or intellectual property rights to the company. Okay, they can be issued at discount. 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 Special resolution to be passed, which is valid for 12 months. Special resolution to be passed, which is valid for 12 months. Special resolution to be passed, which is valid for 12 months. Special resolution to be passed, which is valid for 12 months. At any point of time, maximum 25% of total capital. At any point of time, sweat equity shares shall not exceed. At any point of time, sweat equity shares shall not exceed 25% of total equity capital. Total paid up equity capital. At any point of time, sweat equity shares shall not exceed 25% of total paid up equity capital. Okay, in any year, sweat equity shares shall not exceed. In any year, sweat equity shares shall not exceed 15% of paid up equity capital or 5 crores, whichever is higher. 15% of paid up equity capital or 5 crores, whichever is higher. Okay, in any year, sweat equity shares shall not exceed 15% of paid up equity capital or 5 crores, whichever is higher. Or 5 crores, whichever is higher. They have same rights as that of they have same rights and same treatment. They have same rights as that of other equity shareholders. They have same rights as that of other equity shareholders, popularly known as pari passu, means equal footing. Pari passu means equal footing or equal treatment. Technically, it is called as a pari passu, means equal treatment or equal footing. So therefore, they have same rights as that of other equity shares. They have same rights as that of other equity shares. Okay. Therefore, they have same rights as that of other equity shares. If the consideration given, if the consideration received for issue of sweat equity shares, if the consideration received for issue of sweat equity shares does not satisfy the criteria to recognize an asset, if the consideration received for issue of sweat equity shares does not satisfy the criteria, for recognition as an asset, if the consideration received for issue of sweat equity shares does not satisfy the criteria for recognition as an asset, then it shall be treated as a part of managerial remuneration. Then it shall be treated as a part of managerial remuneration. Okay, then it shall be treated as a part of managerial remuneration. If the consideration for issue of sweat equity shares does not satisfy the criteria for recognition as an asset, then it shall be treated as a part of managerial remuneration. Okay, they shall be locked in for minimum 3 years. They shall be locked in for minimum 3 years. They shall be locked in for minimum 3 years. They shall be locked in for minimum 3 years. Sweat equity shares, they shall be locked in for minimum 3 years. Out of this 15% and 25% are important for fill in the blanks. 25% in total and 15% or 5 crores, whichever is higher. 25% in total, 15% or 5 crores, whichever is higher. Startup company 50%, right? Startup company 50% for startup company. 50 it here 25%, right? 50% for startup company for first 5 years. For first 5 years, 50% for startup company for first 5 years. %50 for startup company for first 5 years. Next, close to this sweat equity shares topic is employee stock option plan. Employee stock option plan. Employees stock option plan. Okay, employee stock option plan. Same, directors are issued to options are issued to directors or employees or officers. Options are issued to directors or employees or officers Directors options are issued to directors or employees or officers, but not to independent directors. But not issued to independent directors. But not issued to independent directors. But not issued to independent directors, promoters. But not issued to independent directors, promoters, those holding at least those holding certain percentage. What is this percentage? Those already holds 10% or more shares. And to directors already holding, and to directors already holding 10% or more shares in the company. Okay, and to directors already holding 10% or more shares in the company. This is a prohibited category. This is a prohibited category. Independent directors, promoters, and to other directors already holding 10% or more shares in the company. So to them we should not issue sweat equity employee stock option plan. Okay, minimum 1 year gap between vesting. Minimum 1 year gap between granting and vesting. Minimum 1 year gap between granting and vesting. Okay, minimum 1 year gap between granting and vesting. Minimum 1 year gap between granting and vesting. Minimum 1 year gap between granting and vesting. Okay, until the shares are allotted. Until the shares are allotted. Until the shares are allotted. Until the shares are allotted upon exercise of option by employees. Until the shares are allotted upon exercise of option. Okay, no voting rights will be given. Until the shares are allotted upon exercise of option, no voting rights will be given. Until the shares are allotted upon exercise of option, no voting rights will be given. Until the shares are allotted upon exercise of option, no voting rights will be given. Okay, so for them voting rights will not be given for the options. Okay, company has a freedom to fix the exercise price and lock-in price. Company has a freedom to fix the exercise price and lock-in period. Company has a freedom to fix the exercise price and lock-in period. Company has a freedom to fix the exercise price and lock-in period. Company has a freedom to fix the exercise price and lock-in period. Private company shall pass ordinary resolution. Public company shall pass special resolution. Private company shall pass ordinary resolution. Public company shall pass special resolution. Private company shall pass ordinary resolution. Public company shall pass special resolution. Next, voting rights to preference shareholders. Voting rights to preference shareholders. Voting rights to preference shareholders. Okay. Voting rights to preference shareholders. Preference shareholders will have voting rights with respect only with respect to the following resolutions. Only with respect to following resolutions. Preference shareholders will have voting rights only with respect to following resolutions. One is resolutions affecting their rights. Resolutions affecting their rights. Resolutions affecting their rights. Next, resolutions relating to winding up of the company. Resolutions affecting their rights. Resolutions relating to winding up. Resolutions relating to winding up. Next, resolutions related to reduction of capital. Resolutions relating to reduction of capital. Resolutions relating to reduction of share capital. Resolutions relating to reduction of share capital. Resolutions relating to reduction of share capital. If dividend on preference shares, if dividend on preference shares is outstanding for 2 years or more, if dividend on preference shares is outstanding for 2 years or more, then preference shareholders will have voting rights on all resolutions. If dividend on preference shares is outstanding for 2 years or more, then preference shareholders will have voting rights on all resolutions. Okay, if dividend on preference shares is outstanding for 2 years or more, then preference shareholders will have voting rights on all resolutions. Then preference shareholders will not have will have voting rights on all resolutions. Okay. So there is no difference so far as dividend is voting rights are concerned. So far as voting rights are concerned. So far as voting rights are concerned, there will be no difference between cumulative preference shares and non-cumulative preference shares. There will be no difference between, so far as voting rights are concerned, there will be no difference between cumulative preference shares and non-cumulative preference shares. There will be no difference between cumulative preference shares and non-cumulative preference shares. Their difference is only with respect to dividend. Their difference is only with respect to dividend. Their difference is only with respect to dividend. So far as voting rights are concerned, both are same. No difference between cumulative preference shares and non-cumulative preference shares. Their difference is only with respect to dividend. Okay. Right. Next, voting rights are proportionate to paid up share capital. Voting rights are proportionate to paid up share capital. Voting rights are proportionate to paid up share capital. Voting rights are proportionate to paid up share capital. Voting rights are proportionate to paid up share capital. Okay. Look at this. Year 1, cumulative preference shares, non-cumulative preference shares. Year 1 cumulative preferences and non-cumulative preferences. Year 1 cumulative preferences, dividend not paid. Non-cumulative preferences also, dividend not paid. Year 2 also same. Year 2 also cumulative preferences, dividend not paid. Non-cumulative preferences also, dividend not paid. Then year 3. They will have voting rights. Voting rights will be given. Okay, year 3 voting rights will be given. Voting rights will be given. Year 1 dividend is not paid on cumulative preferences, dividend is not paid on non-cumulative preferences. Year 2 also dividend is not paid, dividend is not paid. Year 3 voting rights will be given. Year 4 cumulative preferences, dividend is paid for all 4 years. Cumulative preferences, dividend is paid for all 4 years. Dividend is paid for all 4 years. Non-cumulative preferences, dividend is paid only for 4th year. Dividend is paid only for 4th year. Okay, non-cumulative preferences, dividend is paid for all 4 years. Non-cumulative preferences, dividend is paid only for 4th year. That means the the difference between cumulative and non-cumulative preferences is only with respect to dividend, not with respect to voting rights. Okay, with respect to voting rights, both are same. If the dividend is not paid for 2 years continuously, from the 3rd year onwards, both shares will get voting rights. Cumulative as well as non-cumulative, both will get voting rights. Their difference is only with respect to dividend amount. Okay, that we should not forget. This is the important point. So both are same. So far as voting rights are concerned, cumulative preferences and non-cumulative preferences are same. Their difference is only with respect to dividend. Preferential offer not equal to offer of preferences. Preferential offer not equal to offer of preferences. There is a difference between preferential offer and preference shares. They are both are not same. Preferential offer not equal to offer of preferences. So preferential offer is a balancing point, balancing or residual category. Residual category. So what is meant by residual category? There are separate provisions for all these things. For all these things there are separate provision. So okay, look at this. Does not include public issue separate provision, rights issue separate provision, employee stock option separate provision, sweat equity shares separate provision, bonus shares separate provision. Anything other than this is a preferential offer. Anything other than this is a preferential offer. Public offer 23 to 41, public offer 23 to 41, sweat equity shares 54, sweat equity shares 54, bonus shares section 63, bonus shares section 63. Okay, employee stock option rule 12, employee stock option rule 12, public offer, sweat equity shares, bonus shares, employee stock option, rights offer section 62, rights offer section 62. So these are the different offers and different sections. Company is offering securities. Company is offering securities that is not covered under any of this category. Company is offering securities that is not covered under any of this category. That is called as a preferential offer. Say for example, company purchased machinery. Company purchased machinery from the vendor. Company purchased machinery from the vendor, and instead of paying cash, company allotted shares. Company purchased machinery from the vendor, and instead of paying cash, company allotted the shares. It is not a public offer, because public offer to be made to more than 200 persons in a financial year. It is not a public offer. It is not a sweat equity shares, because this person is not director or employee providing intellectual property rights. This is not a bonus shares given free of cost. This is not an employee stock option, and this is not a rights issue. Company purchased machinery and rather than paying cash, company allotted shares. This is not covered under any of this category. It is not a public offer, not right shares, not bonus shares, not sweat equity, not employee stock option, balancing figure. That is residual category, which is not covered under any other specified offers. It is called as a preferential offer, where the offer which does not include all other categories. It is called as a preferential offer. Okay. Preferential offer, private placement. Private placement is a broad term. Within that, preferential offer is a minor term. Private placement, preferential offer is a type of private placement. So private placement can be for equity shares, convertible securities and non-convertible securities. Equity shares, convertible securities and non-convertible securities. Okay, so preferential offer is only with respect to equity shares and convertible securities. Preferential offer. Private placement covers all these categories. So therefore every preferential offer is a private placement, but every private placement is not a preferential offer. Every preferential offer is a private placement. Every preferential offer is a private placement. Okay, every private placement is not a preferential offer. Every preferential offer is a private placement. Every private placement is not a preferential offer. In the exam, we should not confuse for the definitions of private placement and preferential offer. Every preferential offer is a private placement, but every private placement is not a preferential offer. Okay, right. So remaining will continue in the afternoon's class. I'll start the directors concept. Okay. OPC, private company, public company, minimum and maximum. OPC will have minimum 1 director, private company minimum 2, public company 3, maximum is 5 for all directors. Maximum is 15 for all directors. Okay, can be increased by passing special resolution. Can be increased by passing special resolution. Okay, so special resolution not required for section 8 company and government company. Special resolution not required for section 8 company and government company. Okay, so OPC 1, private company 2, public company 3, maximum will be 15 directors for all types of companies. That 15 you can increase by passing special resolution. That special resolution is not required for section 8 company and government company. Okay, right. Next, so women director and independent director. So both are important. So in the exam we should not confuse with the limits etc. Women director, independent director. Women director and independent director. Okay, so women director is mandatory for applicability or mandatory. Okay, so women director is mandatory for listed companies. Women director is mandatory for every listed company. Women director is mandatory for every listed company. Next, paid up share capital 100 crores or more. Paid up share capital 100 crores or more. Turnover 300 crores or more. Okay, paid up share capital 300 crores or more. Okay. Next, independent director. Independent director is also mandatory for listed companies. Independent director, listed companies, paid up share capital 10 crores. Listed companies, paid up share capital 10 crores. Turnover 100 crores or more. turnover 100 crores or more. Okay, right. So here in the examination, to avoid confusion about the limits, paid up share cap women director 100 crores and turnover 300 crores. Independent director paid up share capital 10 crores and turnover 100 crores. So just have this basic logic. So in the alphabets, I comes first, right? W comes next. Therefore, independent director limits are low limits and women director limits are more than independent director. After 10, 100 comes, right? After 10, 100 comes, right? So after I, W comes. Therefore, I is 10, W is 100 crores. Okay. Listed company, these are the point. So in addition to those four, in addition to those limits, so independent director is mandatory for some other company also, that is borrowings more than 50 crores. Borrowings more than 50 crores. The difference between these limits, paid up share capital turnover, even if they are exactly 10 crores or 100 crores also, independent director is mandatory. Paid up share capital turnover, even if exactly 10 or 100 crores, independent director is applicable. But borrowings more than, if exactly 50 crores, independent director is not required. Borrowings, if it exactly 50 crores, then independent director is not required. Exceeding. So independent director, when it comes to the borrowings exceeding 50 crores, this is 10 crores or more, 100 crores or more. Okay, so exactly that limits also applicable. So share capital turnover, borrowings only more than 50 crores. This is the additional point for independent directors, not applicable for women directors. Okay, right. Next, number of directors, number of women directors, 1 for all companies. Minimum 1 for all companies. Minimum 1 for all the above companies. Minimum 1 for all the above companies. Okay, minimum 1 for all the above companies. Okay, so listed company, paid up share capital 100 crores or more, turnover 300 crores or more, minimum 1 for all companies. So here number of independent directors, listed company 2. Listed company will be 2 directors. Listed company is required to appoint 1/3 of the total number of directors. Listed company 1/3 of the total number of directors. 1/3 of total directors. Other companies 2 directors. Other companies 2 independent directors. Minimum 2 independent directors. Okay, listed company 1/3 of total directors. Other companies, that means here 1/3 I'll write for this minimum 2. For this minimum 2, this is 1/3 of total directors. So women director is same. All the above companies will have minimum 1 woman director. Listed company, paid up share capital and turnover, only 1. But independent director, listed company 1/3 of total directors, paid up share capital, turnover and borrowings, based on this limit, minimum 2 directors. Minimum 2 independent directors. Okay, right. Next, in case of any vacancy, if they resign or if they disqualify, so in case of any vacancy to be filled within 3 months, to be filled within 3 months, to be filled within 3 months or next board meeting, to be filled within 3 months or next board meeting, whichever is later, later. Okay, to be filled within 3 months or next board meeting, whichever is later. To be filled within 3 months or next board meeting, whichever is later. Okay, so here also the same thing. In case of any vacancy, same point. Okay, filling of vacancy is same for women director and independent director. To be filled within 3 months or next board meeting, whichever is later. Next, independent director, what he was eligible and what he was not eligible. Independent director, for women director, no limits. Women director, no limits. So no restriction on remuneration. No restriction on remuneration. No restriction on remuneration. So for independent director, remuneration, what can be given and what cannot be given. Okay, so what can be given is a sitting fees. Sitting fees means fees for attending the meetings, board meetings. Sitting fees means fees for attending the board meetings. And what, and profit related commission. Profit related commission. Sitting fees can be given and profit related commission can be given. What cannot be given is an employee stock option. In the previous lecture I discussed employee stock option cannot be given for the independent directors. Sitting fees can be given and profit related commission, but not the employee stock option. Okay, so not entitled to any employee stock option, but may receive sitting fees, reimbursement of expenses and profit related commission. Another point is there, reimbursement of expenses for attending the board meeting. Reimbursement of expenses for attending a board meeting. Reimbursement of expenses for attending a board meeting. Okay, that can be given, but not the employee stock option. Okay. Next, nominee director. So nominee director, as the name itself indicates, he is nominated by the government. Two cases. There are two types of nominee directors. There are two types of nominee directors. One nominee director is appointed by central government or state government. Another nominee director is in pursuance of any agreement. Any agreement. So normally bankers, when the banker gives a huge loan, higher amount of loan, in that case they will nominate one director. Therefore nominee director may be of two types. Nominee director nominated by government. Nominated by government. Nominee director is of two types. Nominated by government. Next, nominated by lender as per the agreement. Nominated by lender as per the agreement. Nominated by government, nominated by lender as per the agreement. Okay. Next, so for this, whether to nominate by the government or whether to nominate by the lenders, articles authorization is required for both. If there is no authorization in the articles, even central government cannot nominate a director. If there is no authorization in the articles, even central government cannot nominate a director. AOA authorization mandatory. Okay, AOA authorization mandatory for both. AOA authorization is mandatory for both. So if the central government wants to nominate any director, first they have to force the company to amend the articles. Thereafter only they can nominate a director. If there is no provision in the articles, even if central government also cannot nominate a director, subject to the articles of a company. Subject to the articles of a company. Next, managing director is important. Managing director is also important question. And manager also. Managing director, not whole powers, substantial powers. Managing director will have substantial powers. Substantial means not negligible. Substantial means not negligible. Managing director will have substantial powers. Substantial powers means powers which are not negligible. Not majority of the powers, not all powers, not negligible. That means reasonably countable powers. Okay, we cannot ignore it. Reasonable powers, not ignorable powers. Okay, it's not that all powers, it's not that majority of the powers, substantial powers, that means not negligible. Okay, right. So first of all, he should be a director. So only when a person is a director, then only he will be appointed as a managing director. So he can be appointed by way of articles or agreement, board resolution or general meeting resolution. Okay, how a managing director is selected? How a managing director is selected? By way of provision in the articles, by entering into an agreement, or by passing general meeting in the shareholder meeting, by passing a resolution, or by passing a resolution in the board meeting. Okay, so managing director can be appointed in any of the four ways. Managing director can be appointed in any of the four ways. By way of authorization in articles. Articles can specify the name of a person, or we can enter into an agreement specifically, or by passing a resolution at general meeting or board meeting. So these are the four different ways of appointing a managing director. Four different ways of appointing a managing director. Okay. Next, here the role is important, not the designation. By whatever name called. By whatever name called. That means what the role played by a person is important, not the title. Role is important than the title. Okay, so even though that person is not specifically called as a managing director, based on the job he was doing, based on the work he was doing, we have to assume whether it is a managing director or not based on the title given by the company. Company might not have given a title as a managing director, company is calling him as a director only, but we have to, as an auditor, we have to look at what is the role played by that person. So if he was enjoying reasonable powers, then he is a managing director, even though company is not calling like that. Even though company is calling him as a normal director, company has not given any designation called as managing director. So we have to ascertain the role. Auditor has to ascertain the role. Auditor should not be misled by the title given by the company. Company may be saying only normal director, but you have to read his terms and conditions of appointment. What is the powers given to them? If the powers are reasonable powers, then he is a managing director. Therefore, by whatever name called, irrespective of the designation given by the company, that person can be called as a managing director. Irrespective of the designation given by the company, he can be called as a managing director. Okay. Next, small shareholders director. Those who have invested 20,000 or less amount. Not more than 20,000 face value, not more than 20,000. They are called as a small shareholders director. Okay, small shareholders director. Small shareholders director. Okay, small shareholders director. Okay, so who is a small shareholder? Maximum 20,000 face value of investment. Maximum 20,000 face value investment. Maximum 20,000 face value investment. Maximum, that is face value. So this is the important point here. Maximum and face value. Maximum 20,000 face value investment. That person is called as a small shareholder. Okay, so all these small shareholders, they can elect one person as their director. A listed company may have one director elected by small shareholders. That means this is applicable only for listed companies, and that also optional, not mandatory. Okay, so applicable for listed companies, and that also optional, not mandatory for a listed company. Okay, applicable only for listed companies. Unlike women director and independent director, it is not applicable to unlisted companies. Applicable only for listed companies, and that also optional. Listed company may. Okay, may upon notice of not less than 1,000 shareholders or 1/10 of total number of such shareholders shall have a small shareholder director elected by the small shareholder. That means notice means request. Who is giving a request to the company? Small shareholders. Okay, 10% or 1,000, whichever is lower. 10% or 1/10 of the total number, or 10% or 1,000. 10% or 1,000. 10% of small shareholders director or 1,000 numbers. 10% of small shareholder director or 1,000 numbers, whichever is lower. So they have to give a notice to the company. Okay, so they have to give a notice to the listed company. So after receiving this notice, so this company will think whether it is required to appoint small shareholder director or not. So just because they have given the notice, it is not mandatory for this company. So these persons has a right to request, not a right to compel. Has a right to request the company, not a right to compel. Has a right to request the company, not a right to compel. Has a right to request the company, not a right to compel. They does not have a right to compel, they only have a right to request the company. Shall have a small shareholders director. Maximum 3 years shall not exceed a period of 3 consecutive years. The tenure shall not exceed a maximum 3 years and shall not be eligible for reappointment. So he can be appointed only for 3 years, not exceed a period of 3 years. Independent director can be appointed for 5 years. Small shareholder director is appointed for only 3 years. Small shareholder director appointed only for 3 years. Independent director, he can be appointed for 5 years, and that also after that, after 5 years also he is eligible for reappointment. Okay, up to 5 consecutive years eligible for reappointment. Independent directors up to 5 consecutive years and they are eligible for reappointment. Small shareholder director not more than 3 years, and shall not be eligible for reappointment immediately. At a time he cannot act as a small shareholder director in 2 companies. A person shall hold the position of small shareholder director in more than 2 companies at the same time. No more than 2. No more than 2. Okay, at a same time you can act as a small shareholder director in only 1 company. Okay, but there is no such condition in case of independent director. A director can act as a woman director or independent director in multiple companies at a time. A single person can act as a director in 20 companies. At a time, a person can work as a director in 20 companies. But in small shareholder position, you can act only in 1 company at a time, not 2 companies. There is no such requirement for independent directors and women directors. Next, first directors. So first directors will be mentioned in the articles. If the articles are silent, then subscribers to the memorandum will act as a first directors. First directors will be mentioned in the articles. If the articles are silent, then subscribers to the memorandum shall be first directors. Next, this is very important. Additional and alternative director. Very important. Additional and alternative director. Okay. Additional director. So section 161 provides that the articles of a company may confer on its board of directors the power to appoint any person other than the person who fails to get appointed as a director. So additional director power is given to the board of directors. In both the cases, additional director and alternative director. So normally additional director is appointed temporarily because he has to retire in the next meeting up to the date of the next AGM. That means he is working only for 1 year. Now I am appointing in the month of December 22. Next AGM will be conducted in September 23. This additional director will be there only for till September 23, not permanently, because of the increase in workload. On an urgent basis, directors are appointing 1 new director without shareholders' consent. Normally, in general, appointment of directors is in the hands of the shareholders as a general rule. Unless otherwise specified, appointment of directors is in the hands of a shareholders. All this independent director, small shareholder director, etc. But here additional director is appointed by the board. On an urgent basis. That is the reason not permanently we are carrying. We are carrying only till the next AGM. If the shareholders like the performance of this temporary director during the 6 months or 9 months, they can make it as a permanent director. Additional director can be regularized in the AGM. Okay. Additional director can be regularized in the AGM. So therefore the concept is, in general, shareholders has a power to appoint directors, but due to increase in the workload, directors may appoint, board of directors may decide to appoint 1 additional director. He is very temporary because he will continue only till the next AGM. Okay. So if the shareholders if the shareholders like the performance of this person, they can regularize the appointment. Okay, right. Next, alternate director is not like temporary director. He can continue for 5 years or 6 years also. Okay. So when a director is not working in India, absence from India. So when a director is going abroad for a period of 6 months or 8 months, we don't know when he will return, but definitely he is going to stay outside for more than 3 months. In that case, we will appoint 1 alternate director. Okay, alternate director is appointed when any one of the other directors is going abroad and they are expected to stay in abroad for more than 3 months. So if a director is going to abroad and he will return back to India after 10 days or 1 month, then alternate director is not required. But he was not going to come back for 3 months. He may be coming after 8 months or 1 year. Then 1 alternate director can be appointed. So this alternate director will work only till this original director comes to India. Only this original director comes to India, not permanently. Okay, right. That is the point. So to act as an alternate director, so director is absent for a period of not less than 3 months. That means one of the director is leaving India, he was going abroad for not less than 3 months. Then we have to appoint 1 alternate director. Okay. Next, there are two concepts, rotation of directors and retiring directors. Rotation of directors and retiring directors. Rotational directors is one concept. Rotational directors is one concept, and retiring directors is another concept. Rotational directors and retiring directors. First of all, this rotational director concept is applicable only for public companies. This rotation of directors concept is applicable only for public companies. So rotational directors, 2/3 of the total number of directors. 2/3 of total number of directors. 2/3 of total number of directors, and retiring directors 1/3 of rotational directors. 1/3 of rotational directors. 1/3 of rotational directors. Okay. 1/3 of rotational directors. Say for example, total directors are 9. Total directors are 9. Out of the 2/3, that means 6 persons should be rotational directors, and 3 can be non-rotational directors. Non-rotational means I can appoint them as on a permanent basis or for a lifetime basis. Then I need not change these 3 positions. Out of 9 director positions in the company, 3 directors positions I have selected as a key positions. I am not going to change the persons in these positions. Okay, but these 6 positions I can rotate. Rotational directors. So that means these 6 positions, out of these 6, 1/3, that means 2. Out of these 6, every year 2 directors needs to be changed. Out of the 6 directors, every year 2 directors has to be changed. Say for example, I have appointed A, B, C, D, E, F, 6 directors. Now in the current year, out of these 6 directors, whoever appointed first, FIFO basis, first in, first out. First in, first out. Who stays longer period of time in the company? Who stays longer period of time in the company? He has to retire from the office. Longest in office. Longest in office. So who was staying in the company for more period of time? Longest in office means first appointed. So out of these 6 persons, we'll see the dates of appointment of each this person. The 2 most seniors will be removed. As simple as that. 2 most seniors. Out of these 6 persons, 2 most seniors who appointed earlier, they will be changed. So AB, I will change it as a GH, I will appoint new persons. In place of AB, I will appoint new persons. So next year, GH, CD, EF will be there, right? So this GH is latest appointed, but obviously these 2 are old. So out of this, whoever is there, I will change these persons. So now GH is there. Now can I appoint again AB? The answer is yes. I can appoint again AB, or I can appoint JK also. But every year I have to change 2 positions. 2 new directors should come. Okay, that is the reason. So therefore, this total number of directors is 6. Out of this 6, this total number of directors are 9. Out of that, 6 directors should always be in rotational. These 3 I am not going to disturb. These 3 I am not going to disturb. These 6 I will rotate. Okay. That is rotational directors, retiring directors, and rotational directors. Next, disqualifications are very important question. Like disqualifications of auditor, disqualifications of directors are important questions. Disqualifications for appointment as independent director. You can expect a practical question also. So therefore, we have to read in detail. A person shall not be eligible for appointment as a director of a company if he is of unsound mind is first point. And unsound mind as per the court order, okay, and insolvent. So you have applied for insolvent, or court has confirmed as an insolvent. Applied for insolvency or confirmed insolvent. Applied for insolvency or confirmed insolvent. So in simple words, insolvent person. Okay, so disqualifications for appointment as director. Disqualifications for appointment as director. Disqualifications for appointment as a director. Okay, so first one is unsound mind. Unsound mind person and insolvent. Unsound mind person and insolvent persons, they are disqualified. Next, who has been convicted by a court of any offense, whether involving moral turpitude or otherwise. So here we should not forget the word otherwise. So earlier it was involving moral turpitude. Later on this word has been inserted. Therefore, convicted for any offense. Convicted for any offense, whether relating to moral any offense. Any offense, whether relating to moral turpitude or not relating to moral turpitude, or otherwise means any offense. Okay, any offense, whether it relating to moral turpitude or not, any offense. Any offense, and sentenced to imprisonment for not less than 6 months, and a period of 5 years has not been elapsed from the date of expiry of the sentence. If a period has been convicted of an offense for a period of 7 years or more, then shall not be eligible to be appointed as a director in any company. Okay. So therefore here the concept is based on the imprisonment time we have to check. Okay, imprisonment for offense. Imprisonment for offense. Okay, imprisonment for offense. So first thing is not less than 6 months. Not less than 6 months. Not less than 6 months. Say 6 months approximately I'll take 180 days. Say 0 to 179 days. 0 to 179 days of imprisonment. Assume 0 to 179 days of imprisonment. Then no disqualification. 0 to 179 days of imprisonment, then no disqualification. So 6 months or more. 6 months or more. 6 months or more, but less than 7 years. 7 years or more here is, therefore, but less than 7 years. Okay, 6 months or more, but less than 7 years. So disqualification continues for disqualification attracted, temporary disqualification attracted. Temporary disqualification attracted, which continues till. So temporary disqualification attracted, which continues from the date of sentence, that means from the date of going jail. Okay, from the date of sentence till expiry of 3 years, till expiry of 5 years from the release. Okay, till expiry of 5 years from release. Till expiry of 5 years from release. Till expiry of 5 years from release. Say for example, 1st January 2020. 1st January 2020, Mr. A has gone to imprisonment. 1st January 2020, and imprisonment period is say 8 months. And imprisonment period is say 8 months. That means till 31st August 2020. Till 31st August 2020. Imprisonment is 8 months. Therefore, it is more than 6 months. Okay, it comes under the second category. So 1st January, Mr. A has gone to jail and he was staying in jail till 31st August 20. So from here we have to take 5 years. Imprisoned, disqualified. So from the date of expiry of sentence. Expiry of sentence means release from jail. Expiry of sentence means release from jail. So from there 5 years. So 30th August 25. 1, 2, 3, 4, 5, 25. So therefore disqualification is for this period. Disqualification is this for this period. From the date of going to jail till the date of till expiry of 5 years. Okay. Therefore, if imprisonment term is 6 months or more, so in the given case imprisonment term is 8 months. So if the imprisonment term is 6 months or more but less than 7 years, then temporary disqualification attracted. So the temporary disqualification continues from the date of sentence. That means from the date of going to jail. From the date of sentence, that is from the date of going to jail till the expiry of 5 years. Till expiry of 5 years. That is if the imprisonment is 6 months or more but less than 7 years. But if the imprisonment is 7 years or more, okay, if the imprisonment is 7 years or more, if the imprisonment is 7 years or more, so if the imprisonment is 7 years or more, he shall not be eligible to be appointed as a director in any company. That means lifetime disqualification. Okay, so lifetime disqualification. Lifetime disqualification. Okay, so lifetime disqualification. So these are the points based on the imprisonment. 0 to 179 days of imprisonment, no disqualification, 6 months or more but less than 7 years, temporary disqualification attracted. Next, imprisonment 7 year, lifetime disqualification attracted. lifetime disqualification attracted. Okay. Next, other order disqualifying by tribunal order, court or tribunal order. Call money not paid and outstanding for 6 months or more. Call money outstanding for 6 months or more. Call money outstanding for 6 months or more from the date of due date. Okay. Call money not paid. Call money not paid. Call money not paid for a period of more than 6 months from the due date. Call money not paid for a period of more than 6 months from the due date. More than 6 months from the due date. Call money not paid for a period of more than 6 months from the due date. Call money not paid for a period of more than 6 months from the due date. Okay. Next, committed offense related party transactions. Section 188, related party transactions offense during the last preceding 5 years. Okay, committed for any related party transactions offense during the previous 5 years. So these are the disqualifications: unsound mind, insolvent, conviction for offense, call money not paid, related party offense for 5 years during the previous 5 years. Related party offense during previous 5 years. Okay. Unsound mind, insolvent, convicted for offense, call money not paid for 5 years or more. Next, related party transactions offense during previous 5 years. Related party transactions offense during previous 5 years. Related party transactions offense during previous 5 years. So disqualification for appointing a director, related party offense during previous 5 years. Okay. Next, resignation and removal also important. Resignation as well as removal, both are important. This is very important point. So when a director resigned, he has to give a notice not only to the company but also to the ROC. He shall within 30 days from the date of resignation forward to the registrar. Very important point. When a director resigned from the company, he has to give a notice not only to the company but also to the ROC. Okay, and within 30 days of resignation. Okay. Next, so if the director is staying in abroad, foreign director, then on his behalf he can appoint one professional to file this with ROC on behalf of him. Okay. If a director is staying in foreign country, then he can authorize any of this chartered accountant, cost accountant or company secretary to file this document on his behalf. Okay. Next, and the resignation will be effective whichever is later. The effective date of resignation. The effective date of resignation. The resignation of director shall take effect from the date on which the notice is received by the company or the date specified in the notice, whichever is later. Okay. Say for example, director has given a notice to the company. Director has given a notice to the company. Director and company. Director has given a notice to the company. Director has given a notice to the company saying that, sir, I am going to resign. I am going to resign from 1st November 2022. Sorry, I am going to resign from the company from 1st January 2023. He has written like that. The date is specified in the notice is 1st January 2023. But company received this notice. Company received this notice on 15th December 2022. Company received this notice on 15th December 2022. So this is date indicated by director, date specified by director, date specified by director, notice received by the company. Notice received by the company. So obviously common sense applied. Even though company received notice on 15th February, but he's agreeing to stay, he's willing to stay in the company till month end. He is willing to stay in the company till month end. Common sense. Therefore, this is the effective date of resignation. On the other hand, after writing this letter, if he forgets to send this email to the company or post this letter, company received this notice on 5th January 2023. He has written in the notice as written as 1st January, but the letter is received by the company as 5th January. Therefore, whatever happened during these days, whatever transactions happened in the company during these days, transactions in the company, he is responsible. Okay, because legally his effective date is 5th January. Company came to know that he was resigning on 5th January. Therefore, whatever happened, he cannot escape that I am not aware of the company. Okay, that is the point. Whichever is later, date mentioned in the notice or date received by the company, whichever is later. Date mentioned by the company or date received by the company notice, whichever is later. Next, removal of director, similar to removal of auditor. Removal of director is also similar to removal of auditor. A special notice to be given. Special notice means, so notice given by the shareholders to the company. Notice is given by company to shareholders. Notice is given by company to shareholders at least 21 days before the meeting. 21 days before the meeting. Notice is given by company to shareholder. Now shareholders will give special notice to the company. Shareholders will give special notice to the company. So special notice will be given at least 14 days before the meeting. 14 days before the meeting. So to whom the company gives this special notice? Company gives this special notice to all shareholders. Company gives this special notice to all shareholders. Sorry. Company gives this normal notice to all shareholders. But this special notice can be given by 1% voting power or 5 lakhs paid up share capital. This special notice can be given by not all persons, 1% voting power or 5 lakhs paid up share capital. Who invested minimum 5 lakhs in the company or who is holding at least 1% of voting power, they can give this special notice. So after giving this special notice, company will forward that special notice. Company will forward the special notice to other shareholders. Company will forward this special notice to other shareholders. This happens 7 days before the meeting. This will occur 7 days before the meeting, 21, 14 and 7. Okay, at least 7 days before the meeting, company has to forward this special notice to the other members. Company has to forward this special notice to other members. Okay, right. That is what the point. So therefore, it is the shareholders who has to initiate the removal of director. Shareholders has to initiate the removal of director. That is what this special notice. Okay, shareholders should initiate the removal of director. After receiving special notice, company will forward a special notice to the concerned director, and company will give a representation, opportunity to argue. The director concerned may make his representation. That means director can share his views, can share his arguments with the shareholders. So some of the shareholders are removing the directors. Now the directors has a choice to argue in support of him. Okay, representation. That representation. So here the important point is that if the rights are misused, abused to secure needless publicity. Abused to secure needless publicity. Along with the special notice, if the director, the removing director, okay, removing director has given any representations to the company, So what is meant by representations? Supporting arguments. Why his performance is good, why he has performed well, supporting arguments. Okay. This supporting arguments also company should normally send to other shareholders. Representations. Okay. So representation is given by the outgoing director in support of his performance. So normally company has to send that representation to other directors. But if the company feels that he was unnecessarily making publicity for himself rather than talking about the company, if the company feels that director is making unnecessary publicity, then company can make an application to the tribunal. Company can avoid this. Instead, company can make an application to the tribunal. Okay. So what is that application? Company has to justify the tribunal. Sir, as per the act, director has an opportunity. Director has a right to make this representation, but in our case, our director is making unnecessary personal publicity rather than talking about the company. Therefore, we don't want to send his representation to the other shareholders. If the tribunal convinced with the arguments of the company, tribunal will give an order. Okay, you no need to send this representations. Waiver from sending representations. waiver from sending representations. Waiver from sending representations. So tribunal can give an order to the company, that is waiver from sending representations. Okay. Needless publicity if they are using for publicity purpose. This appointment of managing director and whole-time director, special points. So for normal director, no upper age limit. For managing director, upper age limit is 70 years. For normal director, no upper age limit. For managing director and whole-time director, maximum 70 years. 21 years and 70 years. Minimum 21, maximum 70. A company shall not appoint a managing director and a manager at the same time. Logically, managing director and manager cannot be appointed at the same time. Okay. A company can have, so what is the possibilities? Only managing director is possible. Managing director plus managing director, this is possible. Only manager is possible. Managing director plus manager, this is not possible. Okay, a company can have only managing director, or company can have two managing directors, because each managing director is not having full powers. I said substantial powers. Substantial means some powers, not negligible, some reasonable powers. So since all powers are not given to the managing director, there is no objection if you have two managing directors. But manager is given all powers. Manager is more powerful than managing director. Manager is more powerful than managing director. So when you appoint one person as a manager and you have given all powers, from where you will get the powers to appoint a managing director? If you are out of total powers of the company, if I am carving out and I am giving some powers to the managing director and I am giving balance power to the manager, I cannot call this person as a manager. I cannot call that person as a manager, because he was not having full powers. Some powers is already delegated to managing director. Therefore, this is not possible. When I am giving some powers, I cannot give all powers to another person. Logical. When I am giving some person to one person, I cannot give all powers to another person. Manager means a person who has all powers of the management. Manager means a person who has all powers of the management. Therefore, when a company appointed a manager, it is not possible to appoint a managing director. Because if you are appointing a managing director, means you are taking away some powers, and that original manager position is diluting. Therefore, company has these three possibilities. Appoint only one managing director, or appoint two managing directors, or appoint one managing director. So you cannot appoint one managing director plus one manager, logically speaking. Therefore, similarly, another case is that their company cannot have two managers also. 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 Managing director, two managing directors is possible. Only manager is possible. Managing director plus manager is not possible, and two managers also not possible. That is what this point. Managing director and a manager at the same time. Next, a company shall appoint or reappoint a managing director or whole-time director or manager for a tenure of 5 years at a time. Maximum 5 years. Shall appoint or reappoint for a tenure of 5 years. Minimum age limit is 21. Maximum age limit is 70. After 70 years also, you can continue that person by passing a special resolution. You have to pass and you have to give the justification. Okay. So you have to give a justification also. 1944 means more than 70 years, right? 56 plus 22, 78 years. 56 plus 22, 78 years. So this person is also right now acting as a director, managing director in many companies based on this special permission. Okay. So normally 70 years. Normally 70 years, but sometimes you can appoint a person having more than 70 years age also. But for that we have to pass special resolution and you have to give justification. Okay. Remember, to work as a normal director, no age limit. To work as a normal director, no age limit. Ratan Tata is not a managing director in any company. Ratan Tata is not a managing director in any company, but he is a director in many companies. Okay, therefore this provision is not applicable to Ratan Tata. This is applicable only to a person acting as a managing director or whole-time director. Okay, Ratan Tata in all companies is non-executive director, means part-time director. Part-time director. Only for the managing director and whole-time directors, this age limit of 70 will be applicable. Okay. Same disqualifications as we discussed, insolvent, etc. This is also important. His creditors has at any time suspended payment to his creditors. That means in his personal capacity, if a person has avoided payment to the creditors in his personal capacity, then he cannot be appointed as a managing director. That means if a person is not capable of managing his own affairs, then obviously he is unfit for managing the company. So his creditors, so Mr. A and ABC Limited, Mr. A and ABC Limited, and Mr. B. Who is Mr. B? Creditor of A. Creditor of A. Maybe Mr. B has given some goods to A, or Mr. B has rendered some services to A, or Mr. B has some given from property to A. Whatever may be the reason, some money is due from A to B. Some money is due from A to B. Okay, because of goods or because of services or because of selling the property, or maybe B has given a loan to the company. Whatever may be the reason, some money is due from A to B. Therefore, we are saying B is the creditor of A. Now, if A is unable to pay money, A is unable to pay this money, that is not related to the company. That is his personal affairs. But if A is unable to prepay this amount and A is asking B to make some compromise or settlement, A is asking B to make some compromise or settlement, then A is unfit for running this for acting as a managing director of this company. As simple as that. So if you are not able to manage the small affairs of your personal case, then obviously you are unfit for managing. In fact, you are a managing director. You are managing the company, not a normal director. So therefore you are unfit for the managing director. Okay. Composition. Suspended, has at any time suspended payment to his creditors. His creditors means personal transactions. His, not of the company. Not of the company. I hope you are aware of this remunerations limits, right? Okay, so overall remuneration is 11% of net profits. Overall remuneration to whom? Overall remuneration to managing director, whole-time director, manager. So these three persons together are called as a managerial personnel. These three persons are together are called as a managerial personnel, plus other directors, plus other directors, plus other directors. Overall remuneration plus other directors. So this together combined maximum 11% of net profits. Maximum 11% of profits. Overall remuneration, managing director, whole-time director plus manager, other directors. Managerial person, maximum 11%. Maximum 11%. So this is the aggregate limit. This is the aggregate limit. This is the aggregate limit. Next we'll have a sublimits also. Next we have a sublimits also. So sublimits managerial personnel. Sublimits managerial person, how much is the sublimit? 10%. Okay. Shall not exceed 10%. There are more than one whole-time director. So sublimits managerial person. Company has more than one managerial person. Company has more than one managerial person. Company has only one managerial person. If company has more than one, only one managerial person, 5%. More than one, all 10. Maximum 10% all. Okay, 10% to all managerial persons. 10% to all managerial persons together. 10% to all managerial persons together. If company has more than one manager person, 10% to all manager persons. Therefore, balance 1% for all other directors. 1% for other directors. 1% for all other directors together. 1% for all other directors together. 1% for all other directors together. Okay. 1% for all other directors together. Next year, if the company has only one manager person, that manager person will have 5%, and all the other directors together it will be 3%. Okay. Together it will be 3%. 3% for all other directors together. 3% for all other directors together. Okay, so overall remuneration is 11%. Overall remuneration is 11% to managing director, whole time director plus manager plus other directors. Together it is 11%. So only if company has more than one manager person, then 10% to all and 1% balance. If company has only one manager person, here we are not taking 6%, we are taking only 3%. So 3%. Okay, that is the remuneration limits, right? So this is recovery of remuneration. So this profits, this 11%, 5%, etc. we are applying upon profits. We are applying on profits. Say current year we got some 10 crores of profit. Based on that 1.1 crore we paid as a managerial remuneration. But after 2 or 3 years or after 5 years, when some fraud is detected in this financial statements, and the profit is recomputed to say 8 crores. So current year we computed a profit as 10 crores, on that we paid 1.1 crore as a remuneration. After 3 years some fraud is detected in the financial statements and profit is recomputed. Profit is recomputed to 8 crores. If profit is recomputed to 8 crores, so then what happens about the excess? 8 crores into 10%, 0.8 crores. So 0.8 crores is the eligibility, 0.3 crores is the excess that has to be recovered. Recovery of remuneration, restatement of financial statements, okay. So due to fraud or non-compliance with any requirement, already we have paid the remuneration, but when the financial statements are restated due to the fraud, then we can recover. Company has a right to recover that excess amount. Okay, next, powers of directors. There is no list of powers given to the directors in the company. Okay, duties has given the list. The Companies Act has given the list of duties. What are the duties of directors? But companies has not given any list of powers of the board. Okay, right. So powers of the company minus powers of shareholders is equal to powers of directors. Powers of directors is equal to powers of shareholder, powers of company, total powers of company minus powers given to shareholders. Total powers of the company minus powers given to shareholders. So where we can find out for this total powers? Total powers of the company as given in its MOA. So powers given to shareholders, from where you can find out the powers given to shareholders? As given in Companies Act 2013. Okay, so whatever you write in the MOA, out of that Companies Act will say this will go to the shareholders. Only shareholders has a right to exercise the power. The balance all powers of the directors. Okay, powers of directors. So most of the students are confusing about this list. So these are the powers of the directors, like to make calls, buyback, etc. No, the main powers is this point, all powers. What this list specifically says is that they have to conduct a meeting with respect to these matters. Remaining matters without conducting meeting, everybody can simply send their mail to the company, can give their consent to the company. So with respect to the shareholders, we have two options. With respect to the shareholders' opinion, company can take shareholders' consent or opinion on any matter by two ways, either by conducting general meeting or through something called as postal ballot. Okay, company can take shareholders' consent either by passing a resolution at general meeting or postal ballot. So what is general meeting? Face-to-face discussion. Postal ballot, no face-to-face discussion. Okay, postal ballot, no face-to-face discussion. Company will send its proposal to the shareholders through post or email. Shareholders will send their reply through post or email. No face-to-face discussion, no meeting at all. Okay, that is postal ballot. Similarly, for directors' consent also we can do the same thing. That is board meeting. Directors' consent also we can say board meeting. And corresponding to the postal ballot is called passing a resolution by circulation. What is postal ballot to the shareholders? Is nothing but a resolution by circulation to the directors. Same thing. company's proposal is sent to the directors through post or email, they will give their reply through post or email. No face-to-face discussion. Board meeting, general meeting, postal ballot, resolution by circulation. This point says these are the special matters where we cannot use resolution by circulation. There where we cannot use resolution by circulation, we have to conduct only board meeting. We have to conduct only board meeting. That is what the point. So majority of the students are confusing that powers of the board means they are writing these points. No, these are the powers which should be exercised only at the board meetings. These are the powers which should be exercised only at the board meetings, which cannot be discussed through resolution by circulation. Okay. Therefore, what is the powers of the company? Powers of directors. Powers of directors is equal to total powers of the company minus powers given to shareholders. You can expect a separate question based on this list also. But when the examination question says write a short note on powers of the board, don't forget to write this the point. This is the main point. When the question specifically says list out the powers which are to be discussed at board meeting only, then we can think of these powers. Okay. If the question asks about simply powers of the board, then we have to write the first point. If the question specifically says powers which can be discussed only at board meeting, then we have to discuss this point. Making calls, buyback, issuing debentures, taking loans, okay, approving financial statements, etc. So all this can be discussed only at the board meeting. Next, so restrictions on powers of board. So this is powers given to shareholders. This is one of the example. Section 180 is one of the example. Those are powers of the board only with the consent of company. With the consent of company, all shareholders together is called as a company at general meeting. Okay. So outside you are all students. Inside this is a class. Why this is called as a class? Because we are all pulled together. You are all individual shareholders. When you are grooming on road, you are called as a members. You are called as a students. When you are attending in a one single room, all together people is called as a class. Similarly, this is a company, and you are all shareholders. You are all shareholders. So all shareholders, when they come to one place and they sit at the company's meeting, there it is called as a company. All the shareholders, when they collide, when they discuss at the meeting, it is called as a company. All shareholders together is called as a company. So therefore, these powers directors can exercise, but only after taking consent from shareholders. After taking consent from shareholders. Selling the assets of the company. Selling the assets of the company. This is also important theory question. Restriction on powers of board. Selling, leasing, or otherwise the company. If the directors are selling each and every asset of the company, then they need not take the shareholders' approval. Some AC is becoming old, I want to sell that AC as a scrap, or I want to sell this furniture becoming old. For that I need not take the shareholders' consent. That is a routine matter. That is a routine matter. But what I am selling is not an asset. I am selling an undertaking. A branch completely, a factory or a division or a department. So undertaking, selling undertaking is a kind of slump sale. Sale of undertaking is a kind of slump sale. You know the slump sale, right? We are not selling individual asset. I am selling my factory. I am not selling only land. I am not selling only that building. I am not only selling the plant and machinery in that factory. I am not only selling electrical fittings. I am not only selling the license, factory license. I am selling the factory as it is. The land is yours, building is yours, plant and machinery, electrical furniture and fittings, government given license to run the factory, and workers agreement to work in that factory. Everything you will get. I am selling the entire factory. That is called as an undertaking, where I am not assigning value to each and every one of the asset. Okay. Or I am selling one branch completely. I am selling one branch or one department. I am selling completely one department or a division. So normally it is a pool of assets, slump sale. So therefore we understand that every time when the director is selling one asset, they need not take the shareholders' consent. It may not be possible. So when they are selling the assets together as a pool, whole branch, whole division, etc. So further, because selling this undertaking decreases the future income generation capacity of the company. So selling one old AC will not damage the income earning capacity of the company, but selling one factory together definitely will reduces the income generating capacity of the company. So therefore you have to consult with the shareholders. Therefore we have to consult with the shareholders. Next, so invest otherwise than in trust securities. Consideration for amalgamation. Compensation received by it as a result of merger or amalgamation. Compensation received by it as a result of merger or amalgamation. Okay. So amalgamated company is giving consideration, that is money to the amalgamating company, to the amalgamating company, to the amalgamating company. So who is amalgamated company? Buyer. Who is amalgamating company? Seller. Okay, buyer will pay consideration to the seller. What this company has to do with that consideration? They have to distribute that consideration to the shareholders. They have to distribute that consideration to the shareholders. So meanwhile, it's not that today they are receiving immediately, tomorrow entire money they have to distribute to shareholders. It may take some time. After receiving money from the amalgamated company, it may take some time to the directors of this company to distribute to the shareholders. But meanwhile, where I should keep that money? So it may take 10 days or 20 days time to find out the list of all the shareholders, identify their bank accounts or identify their postal address to send the check, etc. So it may take some 1 week, 10 days time or 1 month time. So meanwhile, where should I keep this consideration? Meanwhile, where should I keep this consideration? You have to keep this consideration in trust securities. That means safe assets like government bonds, etc. Trust securities, safe assets, without any risk of fluctuations in value, without any risk of fluctuations in value, without any risk of fluctuations in value. Okay, safe assets without any risk of fluctuations in value, safe assets without any risk of fluctuations in value, that is trust securities. So if this consideration is deposited, invested in some bank fixed deposit, so if I deposit money in the bank fixed deposit, it will not fluctuate, it will increase, there is no question of decrease. I'll keep some 20 lakhs in the bank FD, that will increase only by interest, there is no question of decreasing. But if I purchase 20 lakhs worth Adani Group shares, don't know what happens after day after tomorrow. If I purchase the shares in the stock market, obviously price will fluctuate, then how can I pay money to the shareholders? Pure common sense. I cannot invest this money in the risky assets. I have to invest money in only in the safe assets. No sir, I want to invest in the risky assets. Bank is giving only 7% interest per annum. Bank is giving 7% interest per annum. But if I invest in the stock market, that 7% interest I'll get in 2-3 days. That's it. Rather than keep whatever I'll get, if I keep that 20 lakhs in the bank fixed deposit per annum, whole year I have to keep that money 20 lakhs. In the stock market, I can get in 3 days. Just in 3 days you can get the 2% or 7%. So therefore, what happens if this consideration is say some 50 crores? Say some 50 crores consideration, I have to pay this money to the shareholders maybe after 20 days. After 20 days, 50 crores into 7% per annum, that is 7% divided by 7 divided by 100 into 20 divided by 365. Calculate how much it is. 50 crores I am keeping for 20 days in the bank at 7% rate of interest. $19 lakhs. 50 crores I am keeping at the rate 7% for 20 days. 19 lakhs. Okay. So this is what this is what 7%. So this is for the 7% is for how many days? Banker is giving the 7% for how many days? 365 days. I am keeping my money in the bank only for 20 days. But therefore, if I deposit the same amount in the stock market, 50 crores into simply do 7.57%. Whatever you will get 365 days there, here you will get 20 days. 3.5 crores. Where is 19 lakhs? Where is 3.5 crores? So therefore, it is a good idea only. So keeping bank fixed deposit is for the illiterate people who don't know how to manage the stock market. That is for the people who does not have a financial literacy. So in our company, directors are arguing, sir, 50 crores is not a small amount. If I keep that bank, like retired people or old age people or illiterate people, if I keep in the bank fixed deposit, I am damaging the shareholders. Yes or no? Shareholders are paying me a huge amount of salary. You have to understand there is a good reason why the directors are investing. Directors wants to invest this money in the risky assets. Act says you have to keep the money in the safe asset. But what happens if I keep the money in the safe asset? I'll pay only 19 lakhs to my shareholders. Shareholders are paying me lakhs of 5 to 10 lakhs per month as a salary. Then I have to use my intelligence. If I'm keeping this 50 crores money in the bank fixed deposit, like a retired people or illiterate people, there is no difference between educated people and uneducated people. They will also keep bank fixed deposit, right? So that means you are doing this much of damage to the shareholders. Therefore, directors will say, no sir, it is not at all advisable to keep this much of money in the bank fixed deposit. They will give very less rate of interest. They will give very less rate of interest. Okay, this is bank fixed rate of deposit. Rather, if I invest that money in the stock market, definitely I will get more amount. Yes, you can do it. Otherwise, that's what the point. Otherwise than in trust securities. That means I can go away from the risky asset other than safe assets. Otherwise than in trust securities means other than safe assets. That means risky assets. Other than safe assets. Other than safe investments. Trust securities means safe investments. Trust securities means safe investment. Otherwise, that means other than safe investment. That means I'm investing in risky assets. I'm investing in risky securities. I want to purchase the stock market asset. Is it possible? Yes, it is possible. But you have to take the consent. You have to convince your shareholders. Whatever the calculations I did, you have to convince with the shareholders. See, as per the act, I have to keep money in the bank fixed deposit. But if I keep money in the bank fixed deposit, you will get only 90 lakhs. Same money if I invest in the stock market, I'll get 3.5 crores. Same 50 crores. If I invest for 20 days, definitely I'll get 3.5 crores as a interest. But in the bank, you'll get only 19 lakhs. I have to convince the shareholders. If they get convinced, yes, they will allow me to invest in the stock market risky asset. That is what the point. So whatever the consideration received in the amalgamation, if you are keeping that money in the safe assets, then shareholders permission is not required. Rather, if I am keeping money in risky asset, then I have to take the shareholders consent. Okay. Next, to borrow money otherwise than on to borrow money more than paid up share capital, free reserves and securities premium. Total existing borrowings. Total existing borrowings. Total existing borrowings minus temporary loans. Minus temporary loans. Total existing borrowings minus temporary loans. This is 1 point. Plus proposed borrowings. Plus proposed borrowings. Total existing borrowings minus temporary loans minus plus proposed borrowings. This we have to compare with the paid up share capital, free reserves and securities premium. Paid up share capital, free reserves and securities premium. If this paid up share capital and securities premium is this point, okay, so if this borrowings, existing borrowings minus temporary loans plus proposed borrowings less than or equal to paid up share capital. So paid up share capital is 40 crores, free reserves is 80 crores, 160 crores and securities premium is some 20 crores. Total 120, 140 crores. Paid up share capital is 40 crores, free reserves is 80 crores, 120 crores and securities premium is 20 crores. Total 140 crores. Total 140 crores. So existing I have 120 crores. Existing I have 120 crores. Total borrowings. Out of the temporary borrowings are say 10 crores. Total 110 crores. I can borrow up to 30 crores without shareholders' consent. I can borrow up to 30 crores. Say for example I am borrowing some 10 crores. Say I am borrowing some 5 crores. 5 crores proposed borrowing. 120 crores is my total existing borrowings. Out of the 10 crores is temporary borrowings. I will repay within 6 months maximum. Maximum 6 months I am going to repay. That is not my permanent capital. So therefore net long-term borrowings is only 110 crores. Long-term borrowings is only 110 crores. So now I am proposing 5 crores as a new borrowings. This together, even if I take 5 crores new borrowings, my total borrowings will be 115 crores. So up to 140 crores I can take without shareholders' consent. Up to 140 crores. So rather than 5 crores, if I take this 35 crores, rather than 5 crores, if I take 35 crores, it will be 145. It will be 145. I am crossing this limit. I am crossing this limit. This will be more. Then here board resolution. For this board resolution. For this special resolution. Okay. For this board resolution, this is a special resolution. Okay. Total existing borrowings minus temporary loans plus proposed borrowings, paid up share capital plus reserves plus securities premium. So you have to compare this formula. We have to remove this temporary loans. Next, charitable societies you can contribute 5%. Maximum 5% of 3 previous years profits. net profits of 3 previous years. Okay, current year losses also no problem. Even if the company incurred losses during the current year, still it can contribute to charity, but maximum of 5%. Okay, charitable, so donations, charitable donations in the year T is equal to charitable donations in the year T is equal to donations of charitable donations in the year T is equal to net profit of T minus 1 plus net profit of T minus 2 plus net profit of T minus 3 divided by 3 into 2% into 5% into 5%. Charitable donations in the year T. In the year T, sir, current year 22, I want to pay charity. What is your profits in 21? What is your profits in 20? What is your profits in 19? 2019 minus 1, T minus 1, T minus 2 and T minus 3. So divide by 3. Last 3 years average profits into 5%. This is a charitable donation. So this charitable may or may not be related to my business. May or may not be related to the business. May or may not be related to business. May or may not be related to business of the company. May or may not be related to business of the company. May or may not be related to business of the company. Okay. Next, political parties, there is no limit. They can contribute any amount. Normal charitable societies 5%. Political parties contribution, there is no limit. Any amount. Any amount they can pay. Any amount they can pay. Contributions to political parties. Contributions to political parties. So which companies cannot contribute? Which companies cannot make political contributions? Which companies cannot make political contributions? That is important. Which companies cannot make political contributions? Okay, government companies. Government companies. Newly incorporated companies which have not completed 3 years. Government companies and newly incorporated companies which have not completed 3 years of existence. Which have not completed 3 years of existence. Which have not completed 3 years of existence. Contributions to political parties. Which companies cannot make political contributions? Government companies cannot make political contributions, and newly incorporated companies which have not completed 3 years of existence. Which have not completed 3 years of existence. So how much can be contributed to political parties? No limit. Any amount. No limit. Any amount. Okay. In what forms contribution is covered? In different forms of contribution. Different forms of contribution. Different forms of contribution. Different forms of contribution. So basically 3 forms of contribution. Direct contribution to the party. Which forms of contributions are direct contribution to the party? Direct contribution to the party. Next, advertisement in the pamphlet published by the party. Advertisement in the pamphlet. In the pamphlet distributed by the party. Direct contribution to the party. Direct contribution to the party. Advertisement in the pamphlet distributed. Advertisement in the pamphlet distributed by such party. Advertisement in the pamphlet distributed by such party, or contribution to any person who is mobilizing support for that party. Contribution to any person. Contribution to any person who is mobilizing support. Who is mobilizing support for such party. Who is mobilizing support for such party. Direct contribution to party. Advertisement in the pamphlets distributed by such party. Contribution to any person who is mobilizing support for such party. Who is mobilizing means gathering support. Mobilizing support means gathering support for such party. Who is gathering support for such party. Who is gathering support for such party. Okay. Next, how much contribution? Different forms of contribution. Okay, mode of contribution only through banking channels, not by cash. Okay, only through banking channel. The contribution shall not be made except by an account pay check, bank draft or electronic clearing system. Mode of contribution, mode of contribution only through banking channels, only through banking channels, only through banking channels. Example, check, internet banking, etc. Check, electronic transfer, etc. Check, electronic transfer, etc. Check and electronic transfer, etc. Only through banking channels, check or electronic transfer, etc. Solve the directors topic. I will quickly see this indemnity and guarantee in Contract Act. Industrial laws. Enact. Enact after break I'll see, because now 10 minutes it is not possible to close the enact. Industrial laws. It was long back I have discussed the industrial, where I should check. అది ఎక్కడుందో వెతకాలమ్మా. ఉన్నాయి కానీ పీపీటీస్ అన్నీ ఎప్పుడు 5 years బ్యాక్ చెప్పినవి ఉన్నాయి. బికాజ్ ఇట్స్ నా అవి న్యూ సిలబస్లో లేవు కదా ఇండస్ట్రియల్ లాస్. సిఐపిసిస్లో చెప్పిన పీపీటీస్ ఉన్నాయి నా దగ్గర, బట్ అవి దొరకట్లేదు అందుకని. సో ఐల్ గివ్ ఆఫ్టర్ బ్రేక్ తర్వాత తీసుకొని వస్తాను. ఓకే, ఇండస్ట్రియల్ లాస్. ఓకే, ఏదైనా ఒక చిన్న చాప్టర్ క్లోజ్ చేద్దాం. విల్ క్లోజ్ వన్ స్మాల్ చాప్టర్, ఇండస్ట్రియల్ లాస్. Look at the Gratuity Act, Payment of Gratuity Act, very simplest of all the industrial acts. Okay, so Payment of Gratuity Act. So here normally the eligible employees, okay, eligible employees, 5 years of continuous service, 5 years of continuous service. Okay, 5 years of continuous service. Only those employees who have completed 5 years of service in the company, they are eligible for gratuity. Okay, but the important point is that, so if you work for 5 years, till yesterday your 5 years is completed, today you are not going to get the gratuity. Okay, till yesterday you have completed 5 years of service, today you will not get the gratuity. You will get the gratuity only after retirement, only at the time of retirement, only when you leave, when you are leaving the company. Payment, this is eligibility condition is different, payment triggering point is different. So eligible event is different. Eligible employee, which employees can receive gratuity, who has rendered continuous service of 5 years. Eligible event, so if these employees, so who will get gratuity? This persons. When they will get gratuity is important. When they will get gratuity, at the time of retirement or superannuation, at the time of retirement or superannuation. Superannuation means achieving some age, 58, 60 or 67. So retirement means before that, at the time of retirement or superannuation. So superannuation means after attaining some age, example 58, etc. At the time of retirement or superannuation. This is the eligible event. Eligible employee, 5 years of continuous service. Eligible event at the time of retirement or superannuation. Okay, right. Now, so this 5 years service is not required. Death or disablement. Death or disablement. So if an employee died after joining the company after 2 years or 3 years, if the employee died, then he will then their family members will get the gratuity. Okay, no condition of this 5 years of service. Okay, that 5 years continuous service is not required in case of death or disablement. Okay, so eligible event is at the time of retirement or superannuation. Amount, okay, gratuity amount. How much gratuity amount will be given? 15 days salary. Okay, monthly wage, monthly last drawn wage. So gratuity amount is equal to last drawn wage, divided by 26 days. You will get per day wage, into 15 days. This is per day wage, you will get 15 days wages into number of years of service, into number of years of service. Last drawn wage divided by 26, that will give per day wages, into 15 days into number of continuous of service, rounded off to next 6 months, rounded off to nearest rounded off to nearest. That means if I work for 2.3 years, if I work for 2.3 years, it will be counted as a, sorry, not 2 years. You are eligible only after 5 years. Okay, so if I work for 8.3 years, 8.3 years, it will be counted as 8 years. So 8.7 years, it will be counted as 9 years. Okay, nearest 6 months, more than 6 months, it will be counted as full year. Okay, that is last drawn wage. So this is for monthly wages. Last drawn monthly wage divided by 26 working days in a month. Last drawn monthly wage divided by 26 working days in a month. Now, this last drawn wage in case of piece rated employees. In case of piece rated employees. So in case of piece rated employees, what happens is that is not monthly wage. They will they based on the work they have produced, based on the work quantity or work done. Quantity of work done. Okay, so this is the piece rate wages. So in case of piece rate wages, so you have to take 3 months average. 3 months average. So last 3 months, how much I am earning? So today the employee is retired 2nd December 22. Today employee retired. So how much he has worked in the previous? How much he has worked in the previous? So 1st January, 1st December till you have to take 3 months. Every day his wages is different. Every day his wages is different. No uniform monthly wage. Based on the work he has done, he will get the wages. Now you have to do this average. You have to do this average divided by 3 months. Now you will get this monthly wage divided by 26 you will get. Okay, right. This is the gratuity will be given, death or disablement. So sometimes gratuity will not be given, that is forfeiture of gratuity. Forfeiture of gratuity. In certain cases gratuity will not be given in case of fraud or misconduct, etc. In case of fraud or misconduct, etc., gratuity will not be given. Forfeiture of gratuity, that is also important. Under what circumstances gratuity is not given? All employees who have completed 5 years of service are eligible for gratuity. All employees who have completed 5 years of service are eligible for gratuity. Okay, whether they are doing manual work, manual or otherwise, technical, etc., any work, employee doing any kind of work is eligible for gratuity. Next, in the event of death, the gratuity will be given to the family members. We have to make nomination. Continuous service. This continuous service also important definition. Continuous service. So it is not that continuous service means every year, every day, 365 days we have to work. Not necessary. Not necessary to work 365 days in a year. 190 days in a year if the company is working for less than 6 days a week. So if the company is working for less than 6 days means 5 days a week, like software company. Okay, like software company which work for 5 days a week. Software company which work for 5 days a week. So since the company is working for 5 days a week, that means approximately 52 weeks, right? 52 weeks into 5 days. How many days you will get? 260 days you will get. Out of this 260, it is sufficient if you attend 190 days. Out of this 260, it is sufficient if you attend 190 days. Okay, so you can take some personal leaves, etc. Out of this 250, 190 days is enough. Next, 240 days in any other case. In any other case, 240 days. That means normally 6 days are worked into 52 weeks. How much it is? 312. 312. 56 is 300, 26 is 12, 312. Okay. Right. So out of this 312 days, 240 days you have to work. Continuous service means not throughout 365 days you have to work. This is sufficient if you work this many days. Okay. So continuous service is the important definition in this gratuity, and forfeiture of gratuity is also important. So gratuity is paid in this event: superannuation, retirement, resignation, death or disablement. As I told you, immediately after completion of 5 years you will not get the gratuity. Immediately after completion of 5 years, you will not get the gratuity. You will get the gratuity only after this. You will get the gratuity only after, only if any of these event occurs. You will get gratuity only if any of these event occurs. Okay. Next, forfeiture of gratuity, because employee is terminated. Employee has been terminated due to his negligence. Due to employee negligence, any loss or damage occurred to the employer. Due to employee negligence, any loss or damage occur to the employer, so employer will terminate the employee. Very important point based on the previous case laws is that if an employee has committed some fraud or negligence, etc., immediately you have to terminate. If you excuse, you are not terminating the employee, you are excusing and you are continuing the employee. At the time of retirement, you have to pay gratuity. then you cannot escape saying that you have committed some fraud because of your negligence, some loss or damage occurred to your property, therefore will not get the gratuity. No, if you excuse by not terminating, then he is eligible for gratuity. Okay, if the therefore only if the employee is terminated, then only the gratuity is forfeited. Even though employee's negligence is there, even though loss or damage occurred to the company's property, but still company has excused that employee, company has not terminated that employee, then he is eligible for gratuity. Okay, if he is terminated, then only he is not eligible for gratuity. So these are the case laws you have to go through. Next, amount of gratuity lost on wage divided by 26, you will get per day wage into 15 days into completed year of service. 15 days completed year of service, that is the gratuity amount we have to calculate. So remaining will come after the break. So gratuity act, this case laws also important. We cannot ignore the case laws also. You need not write the name of the case law, but at least you have to write in a well-known case law it has been held that. At least you have to write like this. In a well-known case law, it has, in a well-known case law, it has been held like that. It has been held like, it has been held that. Okay, in a well-known case law it has been held that. Okay, that you have to write. So these are the case laws. Whether the teachers are covered, yes, because they're saying any work, manual or otherwise. Normally, because people are confusing gratuity act, all this labor legislation comes only in the factories where the people are engaged in some manufacturing activities. That wrong notion is there. Okay, these are labor welfare legislations. Those who are working in factory, engaged in production of goods, those who are doing manual work, So people has that wrong notion. Therefore, the act and the definition says whether working in manual or otherwise, engaged in any kind of work. Watchman to the managing director, everybody is employee. Right from the watchman till the managing director, everybody is employee, everybody is eligible for gratuity, manual or otherwise. So therefore, any kind of work, teachers are clearly covered by the definition of employee. Okay, right. Next, employer. So if the entity is covered under the control of belonging to the central government or state government, that means if it is a government factory, then head of the ministry or department is a employer. If the factory is under the control of central government or state government, then head of the ministry is the employer. If the factory is under the control of any local municipality, then chief executive officer is the employer. In other cases, that these are all for government companies only. Right. So in any other case, so normally this is relevant for us. In any other case, a person who has ultimate control over the affairs of the company by any name. So a person who has ultimate control over the affairs of the company, you call it as a managing director, president, chairman, any designation. You use any designation. A person who has ultimate control over the affairs of the company is the employer. Okay, so employer definition will write central government or state government controlled entity, head of the ministry, okay, head of the ministry or department, local authority controlled entity, then chief executive officer of such local authority, like our municipal commissioner, etc. Chief executive officer of the local authority. Next, other cases, normal companies. A person who has ultimate control over the affairs of the company. Okay. Next, so why this family is required? Because a person has to make a nomination. Within 1 year of joining the entity, he has to make a nomination, and the nomination must be in favor of only family member. Okay. Each employee who has completed 1 year of service shall make nomination. Nomination is mandatory. Unlike Companies Act, shareholder nomination is optional. Here nomination is mandatory. Every company, every employee who has completed 1 year of service shall make a nomination, and the nomination must be in favor of one or more members of his family. Shall be made in favor of one or more members of his family. Okay. And any nomination made in favor of a person who is not a member of his family shall be void. Therefore, nomination shall be made only in the favor of the family members, not in favor of friends or relatives, etc. Close family members. So, for this purpose, we should know what is a family. Nomination is mandatory within 1 year. So, after 1 year, after completion of 1 year, they have to make a nomination. So, for that purpose, this family definition you have to read. That family definition. Next, superannuation also definition, 2 marks they can test. The superannuation means attainment of age. Superannuation means attainment of age. So if a particular employee attains the age of say 52 or 60, shall vacate the employment. A person attaining some age, like government entities, retirement will be there for 58, 60, 62 years, like that. So that is that attaining that age at which they have to vacate the employment. They have to leave the company. Attainment of age at which they have to leave the company, that is called as shall vacate the employment. Attainment of the age at which they have to vacate the company, that is called as shall vacate the employment. Okay, right. So wages definition, all these definitions are important only. Wages definition, so particularly we have to careful about for true or false, what is included and what are not included. And includes dearness allowance. Includes dearness allowance, but does not include bonus, commission, house rent allowance, overtime, etc. Only basic wages plus dearness included. Any other allowance is excluded. Therefore, simply remember basic wages plus dearness allowance. Basic wages plus dearness allowance is included. All other things are excluded. Bonus, commission, HRA, overtime wages, all are excluded. This continuous service we have seen. If the entity is working employee during the, if the employee is working in the company from the beginning 12 calendar months, okay, employed during the period 12 calendar, that means if the employee is working in whole year of the company, then out of whatever the dates we have calculated, 260 and 312, right? If the employee is working throughout the year, right from the beginning, he was in the company from the beginning of the year, then out of 260 days he can attend 190 days, and out of 312 days he can attend 240 days. But what if the period of 6 calendar months, for the period of 6 calendar months, that means say for employee has joined, if the financial year starts on 1st April 21 to 31st March 2022. 31st March 2022. So here we have discussed this, right? 8.4 years, say 8.3 years. What is meant by 8.3 years? 8 years, 4 months. 4 months, 1/3 of the year. 8.3 means 1/3 of the year, that is 4 months. 8 year, 4 months, right? So now if the employee is working for 8.9 years, how much you can take? 8.75 years. 8.75 years. So 0.75 years means what? 9 months. Yes or no? 0.75 year means 9 months. Okay, if an employee is working for 8.75 years, 8.75 years, that means 8 years, 9 months. Now in this case, I cannot take this 190 or 240, right? 190 or 240. For that 9 months, I have to take this 95 days or 120 days. Okay, during this 9 months, he has to work either 95 or 120 based on the organization, because I cannot, this is not possible. 9 months, this is not possible. That is the reason. For 12 months, this is calculated, and for fraction of 6 months, this calculations will be done. Okay, so these are the deemed working days. Laid off. When the employer is not having sufficient work to give to employees, then layoff will come. When the employer is not having sufficient work, then layoff will come. Okay, or leave with full wages. If the company is paying wages, means even if the employee is on leave, we have to consider as if he was working. Okay, deemed to be working days. These are deemed working days. These are deemed working days. These are deemed working days. Okay, next, temporary disablement. Temporary disablement arising out of and in the course of employment. Temporary disablement, that also deemed working days. Due to some accident he was not working, he was on leave, that is also considered as week. And in case of female employee, maternity leave also considered. So these are deemed working days. While counting this 190, if an employee has worked for 170 days and all these days comes for 20, then he is deemed to be in continuous service. Actual working days plus deemed working days should be this 190 or 250. Actual working days plus deemed working days should be this 190 or 240. Okay, actual plus deemed working days. Next, in case of seasonal establishment, in case of seasonal establishments which works only in summer or which works only in winter, in that case 75% of the actual working days. 75, if my company runs only 4 months in a year, if my company runs only 4 months in a year, then obviously how can I get this 190 or 240? Whatever the actual working days, in that I have to work 75%. I have to work 75%. Okay. This already we have discussed. These are the events. These are the events triggering eligible event. Only if this event occurs, then only gratuity will be paid. Only if that event occurs, gratuity will be paid. Superannuation, retirement, resignation, death or disablement. Okay, maximum gratuity is 20 lakhs. After this calculation, after doing this calculation, if you get more than 20 lakhs, you will get only 20 lakhs only. Whatever the formula we have applied, this maximum 20 lakhs. Maximum 20 lakhs. Maximum 20 lakhs gratuity after applying that formula. These are easy to score. Right. So here what this provision says is that in case of disablement, we have to see temporary disablement or permanent disablement. Okay, disablement, permanent disablement, temporary disablement. Permanent disablement and temporary disablement. So in case of permanent disablement, employee will leave the job. Obviously, as the name itself indicates, permanent disablement. He will not work again. He cannot work again because of such a grave accident. He cannot work again. Therefore, permanent disablement. So employer will leave the job. Employee will leave the job. Employee will leave the job. Company has to, employee will leave the job. Company has to pay gratuity whether or not he has worked for 5 continuous service. Okay, company shall pay gratuity. Company shall pay gratuity even if he has not worked for 5 years. Even if he has not worked for 5 years. Even if he has not worked for 5 years. Okay, company shall pay gratuity even if he has not worked for 5 years. In case of temporary disablement, okay, so when the leave period will be taken as working days. Leave period. Why employee was on leave? Because of temporary disablement, because of small fracture, etc. Because of temporary disablement, employee is on leave. Leave period is considered as a deemed continuous service. Leave period is considered as a deemed working days. Okay, leave period is considered as deemed working days. Okay, after completion of leave period, employee will come and do the work, but he may be doing less work. He may be doing less work compared to before disablement. So in that case, you have to calculate the gratuity separately. In that case, we have to calculate the gratuity separately. Say employee has worked total for 8 years. Employee has worked for 8 years, 6 years plus 2 years. Sir, what is this 6 years and what is this 2 years? 6 years is pre-disablement and 2 years is post-disablement. So after joining the company, after 6 years, he met with an accident. Okay, after accident also, he was working in the company. Earlier, he was a collection agent. Or marketing people. So he was doing a big work. But now after the accident, he was not moving here and there. Only somewhere he has to sit and do some clerical work. So less amount of work, lower work. Here he will work lower work. Here we will have higher work. You have to apply that formula separately. So disablement at the time of disablement, wages at the time of disablement. Okay, wages at the time of disablement divided by 26 into 15 into 6 years. Pre-disablement period. And here you have it here, wages at the time of retirement. After 8 years, he was retiring in the company. After 8 years, he was retiring in the company. So he joined after 6 years accident. After accident, he worked for 2 years and then he left the company. So total, he worked for 8 years, 6 years before accident on higher work, 2 years after accident on lower work. Therefore, we have to calculate gratuity separately. Same formula. At the time of accident or disablement, what is his wages? Divide by 26 into 15 days into 6. Here, wages at the time of retirement. Wages at the time of retirement. Divide by 26 into 15 into 2 I have to write. 15 into 2, only 2 years. So total 8 years. Rather than writing 8 years, I am calculating 8 years in 2 different ways, because salary is different. Because salary is different. Because if you are, since even the employee is retiring after 8 years, if you apply this formula, what happens is that employee is at a disadvantage, because after disablement his salary is less. Earlier he was drawing 3 lakhs per month salary. After accident he was drawing only 1 lakh per month salary. 6 years he has drawn 3 lakhs per month. 6 years he has done 3 lakhs per month. After 2 years he was drawing only 1 lakh. Therefore, if you apply this formula 1 lakh at the time of retirement, that is after disablement, it is disadvantage to the employee. Therefore, out of this 8 years, split as 6 years and 2 years. 6 years higher wage and 2 years lower wage. Calculate separately. This is the last drawn wage, no doubt. This is the last drawn wage, but that is less. Last drawn wage after accident, that is less. Therefore, employee will be at disadvantage if you apply the common formula for all the 8 years. Therefore, you have to calculate separately pre-disablement period and post-disablement period. Same formula separately. At the time of disablement, what is the salary? Divide by 26 into 15 days. Okay. Salary at the time of disablement. Salary at the time of disablement, divide by 26 into 15 into pre-disablement period. Pre-disablement period plus salary at the time of retirement, divide by 26 into 15 into post-disablement period. Post-disablement period. Okay, salary at the time of disablement, divide by 26 into 15 into pre-disablement period. Salary at the time of retirement, divide by 26 into 15 into post-disablement period. Okay, so this is how we have to calculate the total gratuity. Pre-disablement and post-disablement. That is what this point. Okay. Reduced wages. After his disablement, he was working on reduced wages. After his disablement, he was working on reduced wages. Right. Next, forfeiture I have discussed already. Terminated only. Only when the employee is terminated, gratuity will be forfeited. Otherwise, gratuity is not forfeited. This is important. Disputes are always important for you. Disputes. If there is a dispute as to the amount of gratuity payable to the employee, controlling authority, labor commissioner is called as controlling authority. So in the exam, don't write a labor as commissioner. For your knowledge, remember labor commissioner. Otherwise, in the technical, it is controlling authority. So controlling authority, the employer shall deposit the gratuity amount with the controlling authority. In case of dispute between the employer and employee regarding how much gratuity to be paid, employer shall deposit the gratuity amount with the controlling authority. The controlling authority, after inquiry, controlling authority has to do inquiry and he has to listen to the parties, hear the parties, listen the arguments of employer and employee, then compute the amount of gratuity. So there is a dispute. There is a dispute. So after dispute, deposit, dispute between employer and employee relating to gratuity. Thereafter deposit, employer has to deposit the gratuity amount with the controlling authority. Controlling authority will do inquiry and will hear the arguments of the parties and then he will determine the gratuity. Determine is compute. Controlling authority will compute the gratuity amount. Controlling authority. So there is a dispute between employer and employee. Employer is deposited gratuity amount with the controlling authority. Controlling authority has to do some inquiry. He has to listen to the arguments of the person. Then he has to determine the gratuity amount. Right. Next, if as a result of such inquiry, any amount in excess of the amount deposited by the employer is found to be payable, the controlling authority shall pay excess amount. So thereafter, excess payment. excess amount. So excess amount, what is employer shall deposit with the controlling authority. Excess amount, so employer originally deposited 10 lakhs, controlling authority computed as a 12 lakhs. Now the employer has to deposit that shortfall of 2 lakhs. Common sense, employer has to deposit that 2 lakhs. Employer has to deposit that 2 lakhs shortfall amount. Okay, next the controlling authority shall deposit the amount, shall pay the amount to the applicant. Applicant means nominee or legal heir or employee. Nominee or legal heir, where the applicant is not the employee to the nominee or legal heir of the employee if there is no dispute. So either to the employee or the nominee or legal heir. Either to the employee, nominee or legal heir. That is the disputes. Right. So if the employer does not like this controlling authority order, whatever the amount computed by the controlling authority, if the employer is satisfied with the amount, he will deposit the excess amount. If the employer say this controlling authority calculation is wrong, why should I pay 2 lakhs extra? Then he can go to the appeal. Any person agreed by an order may within 60 days. Order means which order? Order given by controlling authority. May within 60 days from the date of receipt of order, they have to prefer an appeal to the government. Within 60 days, they have to prefer an appeal to the government. Okay. So government, central government or state government. That's why they said appropriate government. Maybe central government or state government. Okay. And this is also, you should not confuse exemption of employer from liability in certain cases. Many times students has written wrong answer for this. Without reading the provision, by using some common sense or guesswork, they have written wrong answer for this. Exemption of employer from liability. So by looking at this heading, students are misunderstanding that exemption from gratuity liability. Exemption from gratuity liability. Exemption of employer from liability. So students are misunderstanding that employer need not pay the gratuity. Exemption is given from the gratuity liability. No, this exemption is from the penalty. So there is some mistake has been done, act has imposed some penalty. So normally to whom the penalty is imposed? To the employer only. Whoever is responsible for that, employer who contravenes. Now the employer has to prove that no sir, no doubt I am the in charge of the factory, I am controlling the affairs of the company, but I have appointed one legal advisor. I am a technical person, I am an engineer, I don't know all these legal provisions. No doubt entire factory is under my control. Everybody will report me only. So entire factory is under my control. But I don't know all this legal knowledge. That's why I have appointed one legal advisor. So that legal advisor has done the wrong computation. So like that he can employ. Employee is charged with an offense. That means employee is charged with an offense means, so government is arguing that employer has committed an offense. Okay, an offense is alleged. Charged means alleged. Complaint is made. Okay, alleged or charged. So that means there is an allegation. Employee is charged with an offense means government. There is an allegation by the government that there is an allegation by the government. There is an allegation by the controlling authority or etc. by the government that employer has committed an offense. Employer has committed an offense. Okay, there is an allegation by the government that employer has committed an offense. That is the meaning of this word, employer is charged with an offense. Now exemption from that, so government is arguing that you have violated the provisions of Gratuity Act, you have to pay this much of penalty. Now the employer is asking exemption from that liability towards the government. Exemption is not from the liability towards the employee. Okay, so employer has to pay gratuity to the employee. For that, this is not the exemption. Employer has to pay gratuity to the employee. Employer has to pay gratuity to the employee. If this is not paid, defaulted, employer has to pay fine, penalty to the government. Penalty or fine to the government. Now we are talking about exemption from this, not from this. Okay, exemption of liability, not liability of the gratuity towards the employee. We are talking about liability of fine. Okay, so this is what this point, liability towards whom? Not towards the employee, not from the gratuity liability. Gratuity liability will be there. Liability to pay this above penalty. Okay, right. Now this is very important. Very exemption of employer from liability in certain cases. where an employer is charged with an offence upon complaint duly made by him and on giving complaint not less than 3 clear days, any other person whom he charges as the actual offender. That means now the government is arguing that employee has committed an offence. Employer is arguing that some other person has committed an offence. Other person whom he charges. Government is arguing that employer has committed an offence. Now employer is arguing that no sir, it is not me who has committed the offence. Some other person has committed the offence to whom I have delegated my work. He has to bring that person before the court. Brought before the court. Actual offender brought before the court. Means employer has to bring that legal advisor to the court. Sir, I am the in charge of the factory. No doubt, as per the definition, a person who has ultimate control over the affairs of the factory is a employer. No doubt, I come under the category of employer only. But I am not looking after this legal issues. Okay, I have appointed some other legal advisor. He has committed the fraud. Now the employer's responsibility to bring the legal advisor before the court. And employer has to prove to the court that that fraud has happened without his knowledge. So managing director has to prove that I have appointed one chartered accountant or company secretary to look after these issues and this person has not monitored that. That is the reason these violations come. Now he is responsible for that. Shall be convicted of the offence. This is very, very important point. Why? Because practically what happens, there are many companies which defaults this gratuity, bonus, etc. crores of money. So what they will do is that they will appoint the chartered accountant, company secretaries, etc. to look after the legal affairs. These chartered accountants and company secretaries, for that small fees of 5,000 or 10,000, they will accept the assignment. Tomorrow if the employer defaults 1 crore, it is the employer defaulted. But the employer say, no, I have appointed a chartered accountant, he did not instructed me to pay this much. Gone. For your 10,000 you have booked. But just by throwing that 10,000 he escaped. He knows that we are not doing any work, but still he'll pay the 10,000 freely. Why? Because tomorrow if something comes, they will catch you, that advisor. So therefore in that case we should be very careful about that. We should not take this employee. Whenever these persons are doing default, our duty what we will do is that we will not take any appointment. We will not take any appointment as a legal advisor. Let the employees of the company only will do. We will only come and give the advice. That's it. On paper, our name will not be there. So in what way you have to discuss with the client? No sir, we don't want any formal appointment. Okay, let your employees do. We will come to your company and we will give training to the employees. If the employees will get any doubt, please ask me. We are just clarifying the doubts. We are not taking the responsibility. We are not taking the whole responsibility. Your employees only has to compute this gratuity amount, everything, etc. Will come once in a week or once in a 15 days and will give some doubts clarification. That's it. But we don't want any formal appointment or responsibility. So in that case, you are safe. So if you are taking whole responsibility, then there is a very risk. So employer will say, no sir, this person has given the advice. Because of that, that fraud has been committed. Okay. You're all seeing the daily news, right? What the many CS has been arrested. Delhi based CA arrested. Okay. These are all the chartered accountants arrested. Okay. It's very dangerous. If it accept the employment, it will be very dangerous. And this protection of gratuity is also important. This will be there in Employee PF Act and Bonus Act also. Protection of gratuity. Protection of gratuity means shall not be attached, not liable to attachment. Protection means not liable to attachment, cannot be attached. No gratuity payable under this act shall be liable to attachment in execution of any decree, order or any civil revenue or criminal court. Very important point. Understand that what that point says is that shall not be liable to attached. Employer is there, employee is there, and employees creditors is there. Creditors of personal creditors of employee. Personal creditors of employee. Personal creditors of employee. So ABC Limited company is there. In that D is an employee. In that D is working as an employee. In that D is working as employee. Now E has given a loan to D. E has given a loan to D or supplied goods or anything. Okay, now D has to pay money to E. So he has taken some 50 lakhs, 30 lakhs loan. So now E has to pay money to D, has to pay money to E. So D did not repay this loan. D did not repay this loan. What happens? Now this E will go to the court. E will go to the court and say, sir, Mr. D has to pay 20 lakhs to me, or he has to pay some 12 lakhs to me. So now E will file a court. Now what the court will give an order to E? Okay, since D has taken a loan from E and defaulted, so whatever the assets of their D, please sell the assets and repay this money to E. That is what is the court order. That is what is the court order. Now E has many assets. Assume he has some amount in the bank savings account, or he has some gold. Okay, sorry, he has some shares. This D has some personal assets. D has some personal assets. Gratuity receivable by the employee from the employer is also an asset to the employee. Gratuity receivable by the employee from the employer is also asset to the employee. That should not be attached. That should not be utilized to pay this loan amount. That is what that not liable to attachment. So employer, employee is having personal liability. If the employee fails to repay that personal liability, that personal creditors, not the business creditors of this employer, the personal creditors of this employee will file a complaint in the court. Court gives an order saying that sell all the assets of this personal, all the personal assets of this employee. Now while selling this personal assets, whatever the gratuity amount given by the employer to the employee, that should not be touched. Okay, that should be given for his livelihood. That should be given for his livelihood. He might have taken so many loans and defaulted, but this gratuity should go only to the employee, not to the creditors of the employee. Gratuity should go only to the employee, not liable to attachment decree. So who is giving the order? Court. In whose favor? In favor of personal creditors of the employee. In favor of personal creditors of the employee. While utilizing that amount in execution, that means as per the order, the creditors wants to sell the assets. Okay, in that case, they should not touch the gratuity. They should not touch the gratuity. Very important. Gratuity and provident fund is also same. Gratuity and provident fund is also same. They should not touch the gratuity and provident. And this is also important. Okay. Display of abstracts of the acts and rules. So gratuity act is giving a benefit of gratuity to the employees. Employees who has worked for 5 years or more, they are eligible for gratuity. But employees are not aware about this benefit. If the employees are not aware about this benefit, obviously employer will take advantage of it and employer will not pay that amount. If the employee is not asking gratuity because they don't know this gratuity act, that employees who are illiterate people, they don't know about all this gratuity act. Therefore, they will not claim about the gratuity. Not illiterate people, many educated people don't know that there is a gratuity. So as per the gratuity act, we have discussed, right? Any kind of work he is eligible for gratuity. But many people are not aware about this gratuity. They are simply leaving the company without asking gratuity from the employer. I have seen hundreds of cases where the employees have simply left the job without asking for gratuity. In fact, employee is eligible for gratuity. They are not asking gratuity for the employer from the employer. Obviously, employer will not pay that gratuity. Many cases it has happened. So therefore, what the act said is that since many of the employees are not aware about the gratuity act, important points, important abstract of the act means important provisions of the act, important provisions of the gratuity act, that we should display at the notice board of the entrance. The employees will say, okay, this is the gratuity act. As per this gratuity act, I'll get this benefit. As per the bonus act, I'll get this benefit. Important abstracts, important provisions of the act. Abstracts means not the entire act. They will not understand the entire act. Like how I am giving running note simple. So in simple words, you have to give the act. Important points of the act. The employer shall display an abstract of the act. Okay. Inform you. That means out of the act, what is important? Out of the provisions of the act, what is important? That act only has decided. Otherwise, the employer will select only what is important to the employer. For a feature of gratuity, that is beneficial to the employer. That is beneficial to the employer. So employer will select only that provisions which are beneficial to the employer. Therefore, that choice is not given. Out of this act, what is important already government has selected. That short notes government has already prepared. The employer need not prepare the short notes of the act. Government has already prepared the short notes of the act. Simply have to display that in English and in the language understood by majority of the employees. Because English also many people may not be able to understand English also. Therefore, language understood by majority of the employees at the entrance. At the entrance. Okay, many companies will not do this. That is the reason employers are not aware. Employees is not aware. If at least if they have displayed, so you are working in the company for past 8 to 10 years, one day or the other you'll observe that, right? If not daily, if you are working for 10 years and there is something in the notice board, one day or the other casually you'll observe that, oh, there is a gratuity, I'll get this much of benefit. Okay, that is the reason. Most of the people are not doing even this also. Okay, abstract of that they are not displaying because they don't want to pay the gratuity. They don't want to pay the gratuity, but whereas this has to be paid by every establishment at the main entrance of the establishment. Subtracts of the act in form number U. Okay. Employees Provident Fund Act, Employees Provident Fund and miscellaneous provisions. Why the miscellaneous provisions? Because of these two also covered, pension fund and deposit insurance. That's why the act is called miscellaneous provisions. Employees Provident Fund Act and miscellaneous provisions act. So there are three concepts covered under this act, that is provident fund, pension fund and deposit insurance. So provident fund is a lump sum amount payable at the time of retirement. Pension fund is a monthly amount after retirement till death. Deposit insurance, lump sum amount in the event of death. Deposit insurance, lump sum amount in the event of death. So these three concepts are covered under the PF Act, Employees Provident Fund Act. So this is applicable only to the entities in which 20 or more persons are working. To every establishment which is a factory engaged in any industry in Schedule 1. Schedule 1 covers almost all every business. So factory in which 20 or more persons are employed. And to any other establishment employing 20 or more persons. Okay. So as of now, the Provident Fund Act is applicable to almost all entities. Almost all entities having 20 or more employees, having 20 or more employees. But in the important point is this one: once the act is applicable, even if the number of employees falls below 20, the act continues to apply. Once applied, always applied. Okay, once applied, always applied. The act is applicable to establishments having 20 or more persons. Once the act is applied, thereafter if the number of employees falls below 20, then also the act is applicable. This is applicable even in respect of home workers engaged through contractors. So contract employees also this is applicable. Not only direct employees but also contract employees. Say for example, if you observe in the bank, there will be security guards. Bank, contractor, security guard. Okay, so security guard will get his salary from this contractor, not from the bank. He is not an employee of the bank. Today one security guard will be there, thereafter another security guard will be there. Not only bank, if you observe even in supermarket also. Supermarket, at the entrance there will be one person, some security guard or watchman kind of thing. So supermarket will give contract and there is some security guard in the supermarket. This contractor will pay money to the security guard. You will observe that security guard, they will have an ID card which is not the supermarket ID card. Some other security agency, whenever you go to D-Mart or Reliance etc., at the entrance security guard will be there. Observe that definitely uniforms will be different. Those who are within the supermarket and those outside, uniforms will be different. Observe the ID card, the entity will be completely different. Therefore, this contract employee, so he will send today one security guard, tomorrow he will send another security guard. Why? Based on the availability he will send. So he will pay salary to them. He will pay salary to the security guard. Now supermarket will pay some lump sum amount to this contractor. Okay, so it is his responsibility to arrange this. Now employer will get provident fund. So now it is the responsibility of the supermarket to ensure that this contractor pays provident fund to the employee. So that means out of that, say for example, a contractor agreed 10,000 salary. Contractor agreed 10,000 salary, agreed salary to the employee, 10,000. So this is a principal employer, that means main employer. Principal, very important point. Practically many frauds are happening here or violations are happening here. Primary principal employer, contract employee, very important for the exam. Principal employer, contractor, principal employer, contractor and employee. Principal employer, contractor and employee. Principal employer, contractor and employee. Okay, now the principal employer, say for example his salary is 10,000. Okay, his salary is 10,000. Employee A salary is 10,000. Employee B salary is say 12,000. Employee B salary is 12,000. Now what happens is that he agreed to pay some 4 lakhs assume per month. Okay, how many employees he will appoint, how much salary will pay, that is the headache of the contractor. So principal employer will say, every day I need 2 security guards at the entrance of my supermarket. 24 hours. 24 hours I need some security guard. Whether you'll appoint employees in 2 shifts, 12 hours or 12 hours or 8 hours, like that, three shifts, whatever you do, it is your headache. So according to me, I want 2 security guards at the entrance, 24 hours. So it is his responsibility to get the employees to work as a security guard. So for that I'll pay 4 lakhs. For that I'll pay 4 lakhs to the contractor. That is what is the agreement. Now out of this A, B, 12 lakhs and 10 lakhs. So A salary is 10,000. A salary is 10,000. Out of that 1200 will be deducted. 1200 will be deducted as a provident fund contribution. 12% provident fund contribution. Now the contractor will pay 8,800 to the A. 8,800 to A. Contractor will pay 8,800 to A. Similarly 12,000 is B's salary. Out of that 1440, 12% means 1440. So 1440 means how much it will be? 9,560. 10,560. 10,560. So contractor will pay 10,560 to B. Salary, 12% of the salary is the provident fund. Now 10,560 to B. Now what happens is, out of this 4 lakhs, he has to deduct this 1200. He has to deduct this 1200 and 1440. Has to deduct this principal employer has to deduct this 1200 and 1440 of this employer contribution, plus 1200 plus 1440 of the employer contribution. This is employee contribution and this is employer contribution. Out of this 4 lakhs, this is the provident fund contribution of all the employees. This is the provident fund contribution of all the employees. The balance only principal employer has to pay to the contractor. The balance only principal employer has to pay to the contractor. And this provident fund, he has to deposit with the provident fund authority. He has to deposit with the provident fund authority. So therefore, it is the responsibility of the principal employer to ensure that contractor is deducting the provident fund from the salary of the employees. So therefore, just because the mediator is there, he cannot escape from his liability. Just because the mediator contractor is there, he cannot escape from his liability. Okay, principal employer is also liable. Therefore, through contractors, employers working through contractors, they are also liable. Next, as I told you, wages definition, you have to read all the acts together. Provident Fund Act, Gratuity Act, Bonus Act, all the acts, wages definition you read at a time. Then you'll understand the differences. Above Gratuity Act, what we have included in the Gratuity Act? Gratuity Act, we have included only basic wages plus dearness allowance. All other allowance are excluded. Commission, HRA, overtime, and other allowance also we have excluded. Overtime. This is the Gratuity Act definition of wages. Now PF Act definition of wages. All emoluments which are earned by an employee while on duty or on holidays with wages, but does not include cash value of consideration, dearness allowance also. This does not include dearness allowance. That means they are taking only basic wages, dearness allowance, house rent allowance, overtime allowance, bonus, commission, etc. Bonus is also excluded. Bonus, commission, HRA, overtime allowance, and any other allowance. Any presents means any gifts. That means PF Act says only wages. Basic wages are included. Basic wages are included. Many other things are excluded. Commission is excluded, HRA is excluded, overtime is excluded, dearness allowance is excluded, bonus, all other things are excluded. All other things are excluded. And the cash value of consideration, food concession, etc. Okay, only basic wages are given, including does not include dearness allowance. Gratuity Act includes dearness allowance. Here does not include dearness allowance. Here also employee definition is same, more or less employee definition is same. Employee means an employee engaged in any kind of work. Employee engaged in any kind of work, manual or otherwise. Engaged in any kind of work, manual or otherwise, in or in connection with the work of an establishment, and includes any person who is employed through a contractor. Through a contractor. That means this person is also treated as employee of this principal employer. He is not working directly under me, but he is working through a contractor. He is also my employee only. It is my responsibility only. Working through contractor. Okay. Any work included employed by or through a contractor. Includes. That means I have to take security guards. Provident fund is also responsibility of the supermarket. Okay, financial responsibility is the contractor, but administrative responsibility, that means accountability is of the supermarket. Okay, so ultimately he will bear it because he was working immediately under the contractor. So this employer contribution, this is the financial burden of this contractor. That employer contribution is the financial burden of this contractor. But how far this contractor discharges his responsibility, he has to monitor. Principal employer has to monitor how far contractor is discharging his liabilities. So through a contractor. Okay. So a partner of a firm having a status of a beneficiary will not be employee. Partner will not be employee because partner is a owner. He cannot be called as an employee because he is covered under employer. Why? Because he is having control over the affairs of the establishment. Okay, this is very important here because managing director is treated as an employee somewhere. Somewhere you'll see the directors also can claim this provident fund. Okay, anyway, so this is partner of a firm is not an employee because he is controlling the affairs of the factory. These contributions, the government has raised the rates of contributions from the current. So this is current, they are saying. What is current? Current means what? Present. Present means what? 1977. In their language, 1977 is the current rate. From 10 to 12%. From 10 to 12%. So at present contribution is 12%. There are some entities for which contribution is still 10% or 10%. Somewhere it will be there. You have to read. That is also important for the exam. Normally 12%, but there are some entities still they are paying 10% only based on the exemption. So at present provident fund contribution is at 12%. So wage limit is 15,000. Wage limit is 15,000. This is also important. See, provident fund. Employee contribution of provident fund. Employee contribution Okay, employee contribution means actual salary or 15,000, whichever is lower you have to take. Actual salary or 15,000, whichever is lower you have to take, and thereafter employee desire. Actual salary or 15,000, whichever is lower, employee desire. That means if the employee is drawing for 12,000 salary, 12,000 or 15,000, whichever is lower, 12,000 is lower. So we will apply 12% on this 12,000. Normally we will apply 12% on this 12,000. So if the employee's salary is 18,000, 18,000 or 15,000, whichever is lower, 15,000. The act says you have to pay 12% of this. 12%. This is the minimum contribution. Actual salary or 15,000 into 12%. Minimum contribution. That is minimum employee contribution. Actual salary or 15,000 into 12%. That is minimum employee contribution. Say for example, employee is drawing salary of 18,000 and or 15,000, whichever is lower is 15,000. 15,000 into 12%, it will be 1,800. 15,000 into 12%, it will be 1,800. So this 1,800 is the minimum employee contribution. 18,000 is the 1,800 is the minimum employee contribution. Now if the employee says, sir, I have second income also at my home, I want to save more amount. This is the minimum savings compelled by the government. This is the minimum amount of savings compelled by the government. If the employee wishes, he can save more money. He can give an instruction to the employer, sir, not just 1,800, deduct 3,000 from me. from my salary, or 5,000 from my salary as a provident fund account. I have many sources of other income, therefore I want to save more amount. I want to save more amount. Employee says 3,000 I want to save. Employee can increase this contribution because that is minimum. That is a minimum. But employee should not force the employer also to increase his contribution. Employer contribution is this only. Just because employee is increasing his contribution, he cannot force the employer to increase the contribution. Okay, that is the point. So employee has an option. Employee has an option to increase his contribution. 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 Okay, but when employee increases contribution, but when employee has increased his contribution, employer does not have an obligation. Employer does not have obligation to increase his contribution also. But when employee has increased his contribution, employer does not have obligation to increase his contribution. Employer does not have obligation to increase his contribution. Most important true or false question, or fill in the blanks question. Throughout this chapter, this is the most important point. Employee has an option to increase his contribution, but when employee has increased his contribution, employer does not have obligation to increase his contribution. Okay. This also important. Recently some disputes are there based on this. Advances and withdrawals. Advances and withdrawals. There is a difference between withdrawal and advance. Advance is a kind of loan. Advance is a kind of loan. Okay, but withdrawal is kind of repayment. Withdrawal is one kind of repayment. So withdrawal from the fund is allowed for the following purpose. So provident fund is not like your bank fixed deposit. Whenever you want, you can withdraw. Okay, so these are the restrictions to withdraw. So for what reasons, for what purpose employee can withdraw his provident fund? For what purpose employee can withdraw his provident fund? For the purpose of constructing a house. For the purpose of constructing a house, he can withdraw. For repayment of loans in medical cases. Withdrawal within 1 year before the retirement. Okay, before the retirement, not after. Before the retirement, next year he was going to retire. Now he can withdraw the amount, because it doesn't matter. Anyway, after 1 year he will get full amount. Okay, now employee is 57 years of age. After 58 years, employee will retire. At the time of retirement, provident fund full amount will be paid. What is provident fund? Here we have written what is provident fund. Lump sum amount paid at the time of retirement, right? Provident fund means lump sum amount payable at the time of retirement. Therefore, anyway, next year employee will retire and he will get full amount. Therefore, what's wrong if you are asking 1 year before that? So therefore, he can get withdrawal within 1 year before the retirement. Next, withdrawal up to 75% of the balance, if not employed from 1 month or more, subject to approval of commissioner. Not employed means not doing any job. Not doing any job, idle. Okay, so till now I am working in one company, now I am idle, I don't have salary, then obviously I have to withdraw provident fund. That is my savings only, that is my savings. But you cannot withdraw full amount, only up to 75% as the commissioner approved. As the commissioner approved. Okay, so this is withdrawals. Withdrawals are not required to be repaid. Withdrawals are not required to be repaid. Advances, as the name itself indicates, advances are loans, they have to be repaid. Advances are loans, they have to be repaid. Such withdrawals are not required to be repaid. Advances are required to be paid. Advances from the fund are paid for the following purposes. So for illness, that means for health or marriage purpose. Okay, abnormal conditions such as natural calamities granted to okay, so these are the points. These are the advances. That means this you have to repay after that. This is a kind of loan based on your provident fund amount. This is a kind of loan that you have to repay after that. After joining the company, again you have to repay that amount. So these are withdrawals from the fund and advances from the fund. Definitely I'm sure that this will be outdated provisions only. Definitely I'm sure this is outdated provisions only, not the latest provisions. Okay, so for the sake of examination you stick on to that, but when you go to the articleship you prepare for the updated provisions. This is not updated provisions, this is very old provision. Right, so pension fund, employer contribution of 12%, employer contribution of 12%, employee contribution of 12%. So out of that employer contribution of 12%, okay, 8.33% will go to pension fund. 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 The balance 3.67% and employee contribution of 12%. This go to provident fund. This go to provident fund. Employer contribution of 12%. Out of that 8.33 goes to pension fund. 3.67% and the employee contribution of 12%. This together they will go to provident fund. The important point why we should learn this breakup. Why we should learn this breakup? Because this will not be paid. This will be paid only if you work for 10 years. That will be paid. Okay. That is the 8.33% is pension fund. Next, employees deposit linked insurance. That contribution is only from the employer. No contribution from the employee. Provident fund. Contribution is from both employee and employer. Okay, pension fund only from employer. Insurance scheme. Insurance scheme. The employer shall pay not more than 1% of the basic wages, dearness allowance and retaining allowance. Retaining allowance. The employer shall pay. Insurance amount. Employees contribution of provident fund. Next, employees deposit linked insurance. In addition to that, in addition to this 12%, employer has to pay 1% for the insurance scheme, for the insurance fund. So remember this 12% is applied on what? 12% is applied on basic wages. This 1% is applied on basic wages plus dearness allowance plus retaining allowance. Basic wages plus dearness allowance plus retaining allowance. 1% of basic wages, dearness allowance and retaining allowance. Say maximum 15,000 limit. Maximum 15,000 limit. If salary is more than 15,000, we'll pay 1% only on 15,000. Look at this. Determination of monies dues from employer. Determination of monies dues from employer. Where a dispute arises regarding the applicability of this act to an establishment, the authority concerned may conduct such inquiry as he may deem necessary. Okay. So when there is a dispute between employer and employee, when there is a dispute between employer and employee, the government authority may conduct inquiry. And determine the amount due. Dispute regarding the applicability of the act. So dispute, I am arguing that PF Act is not applicable to me, and PF officer is arguing that PF Act is applicable to me. In that case, they will conduct an inquiry and they will compute the amount. This is same as gratuity, protection against attachment. Protection against attachment, same as gratuity. Provident fund, employer. Provident fund authority. Provident fund authority, employee. Personal creditors of the employee. Personal creditors of the employee. Provident fund authority, employee. personal creditors of the employee. Now whatever the amount due from the provident fund authority to the employee, so these creditors cannot touch that amount. That creditors cannot touch that amount. Amount due from the provident fund to the employee, creditors should not touch that amount. That is protection from attachment. Protection against attachment. Same like gratuity. In case of gratuity, we are seeing employer to employee. Here provident fund authority to employer. Sir, why sir provident fund authority? Because the provident fund to be payable to the employee is not in the hands of employer. Remember, provident fund to be payable to the employee is not held in the hands of the employer, because every month employer is depositing with the government. Every month employer is depositing with the government. Therefore, provident fund will not be with the employer. Employer is depositing every month this much amount with the government. Therefore, your provident fund is in the control of the government, not in the control of the employer. Therefore, provident fund authority to employee, whatever the amount due balance, that should not be attached. Okay, that is protected against attachment. That is protected against attachment. Personal creditors cannot claim that. So some companies I have seen they are manipulating this provision. Some companies they are seeing they are manipulating this provision. So what this provision says, no employer in relation to an establishment to which any scheme applies by reason only of his liability, by reason only of his liability for the payment of any contribution to the fund or any charges of the scheme or the insurance scheme, reduce whether directly or indirectly the wages of any employee to whom they apply. Okay, so the some employees what they have done, say when employer, employee, employee. Now when the employer joined, employer has given a promise that you will get 10,000 salary. You will get a 10,000 salary. Now after certain period of time, after 1 month, what the employer is paying, in many cases in reality they are paying only 7,600. This is agreed salary. At the time of joining, this is agreed salary. At the time of joining, 10,000 is the agreed salary, but they are asking 7,600 only. Actually, they should pay 8,800. They should pay 8,800. Why? Because 10,000 is the gross salary, 1,200 is the employee contribution. Employee contribution. Employer contribution is this additional responsibility. Over and above this 10,000 salary, he has to pay 1,200. That is the rule. 10,000 agreed salary, over and above that he has to pay 1,200. So that means he has to deduct only 1,200 from the employee salary. The remaining 1,200 he has to bear. That is his expenses. But many cases practically I have seen companies are deducting 2,400 and paying 7,600. They saying that this 1,200 is also your salary. What they will say is they will write like this: basic wages say 4,000. Basic wages 4,000, say some dearness allowance 2,000, so provident fund some 1,200, like that they will write. So what they are saying is that out of gross salary, I said this provident fund contribution in the pay slip, in the employee's pay slip, this is a breakup of the salary. This is a breakup of the salary. In the employee's pay slip, this is a breakup of the salary. So strictly speaking, there should not be PF contribution. So over and above the normal salary has to give. This should not be one of the component of your salary. Therefore, what this provision says is that this employer contribution we should not deduct from the employee's salary. Employer contribution should not be deducted from employee's salary. Employer contribution should not be deducted from employer contribution should not be deducted from employee's salary. Employer contribution should not be deducted from employee's salary. Employer should not reduce any other benefit to the employee. Employer should not reduce any other benefit to the employee. Employer should not reduce any other benefit to the employee due to his PF contribution, due to his provident fund contribution. due to his provident fund contribution. So I am running a software company, I am providing cab services. Okay, cab cost I have to bear. But after this PF Act is launched, you joined. Now earlier I am running a company with 10 employees. Okay, no PF liability. Okay, slowly I am providing free cab services to all the 10 employees. Okay, to all my 10 employees in the software company, I am providing free cab services. Slowly my employees has increased to 22. Since the employees has crossed 20, I have to go for provident fund. Now when I am growing for a provident fund, this 12% is employer contribution additional liability to me. This 12% is my additional expenditure. Therefore, what I will do is that, okay, from now onwards, company will not provide cab services. You have to arrange your own transport. Whether you will come by city bus or metro train or your own vehicle, you have to come. Employer will not provide any transport services. Employer is cutting that benefit because of his contribution, because of this contribution. That is not permitted. That is not permitted. Whatever the benefits we are giving to the employees before provident fund, after provident fund also we have to continue the same benefits. Because of his liability, to compensate the provident fund contribution liability, we should not reduce some other benefit. Okay, or another way what some employees will do, till now I am providing canteen services in my company at subsidized rates. Okay, normally if you go outside, 80 rupees or 100 rupees for afternoon lunch. In my canteen I am providing for 20 or 30 rupees at subsidized rates. Remaining employer will bear. Remaining employer will bear. Now after this provident fund contribution, employer is cutting down all this kind of benefits. So that should not be done. That should not be done. Okay, whether directly or indirectly reduce any benefit to the employee. Employer should not reduce any other benefit to the employee. Employer should not reduce any other benefit to the employee due to his provident fund contribution. Due to his provident fund contribution. Okay. This is common question in all the acts. That is a common question in all the acts. Offenses by companies. If the offense is committed by the company who was in charge of the affairs of the company. Recollect from the Negotiable Instruments Act also, last question in the chapter. Negotiable Instruments Act. In case of offenses by company who was in charge of and responsible for the conduct of the business shall be liable. Who was in charge of and was responsible for the conduct of the business shall be liable. And this director, manager or secretary or any other officer due to whose negligence the offense committed, they are also liable. Okay, if the offense is committed by the company. Offense, this is same for every act. PF, gratuity, NI Act, every act same. Last section will be like that. Any act, last section will be like this. Any act, last section will be same. Okay, offenses by companies. Offenses by companies. So persons who are in charge of and was responsible for the persons who are in charge of and was responsible for the persons who are in charge of and was responsible for the persons who are in charge of and was responsible for the company's business, company's conduct of affairs, for conducting company's affairs, responsible for conducting company's affairs. Persons who are in charge of and was responsible for conducting company's affairs shall be liable. Shall be liable. Persons who are in charge of and was responsible for conducting company's affairs shall be liable. Next, director, manager, secretary, director, manager, secretary or other officer of the company shall be liable if the offense is attributable to their negligence. If the offense is due to their negligence. If the offense is due to their negligence. If the offense is due to their negligence. This is the common in all acts. Persons who are in charge of and was responsible, director, manager and secretary. Okay. So we'll take some 10 minutes break, then we'll continue. ఎన్యాక్ట్ చదివినా ఒకటే చదవకపోయినా ఒకటే, పెద్ద తేడా ఏముండదు అందులో. క్లాస్ విన్నా వినకపోయినా పెద్ద తేడా ఏముండదు. అదొక ఓషన్. అందులో మనం ఒక 2-3 ఇంపార్టెంట్ పాయింట్స్ చెప్తాం. ఎగ్జామ్లో అది రాలేదు అనుకో, అయిపోయింది. ఒకవేళ విన్నింది అదే వచ్చినా సరే ఇక్కడ అర్థమైంది వేరు ఉంటుంది, అక్కడ రాసేది వేరు ఉంటుంది. లక్కీగా మనం ఏ టాపిక్ డిస్కస్ చేసామో అదే వస్తే తప్ప, యాజ్ ఇట్ ఈస్గా అదే వస్తే తప్ప దాని పెద్ద డిఫరెన్స్ ఏమి ఉండదు. అది చదివేటప్పుడే బాగా ఫిల్టర్ చేసుకొని నీట్గా చదవాలి, చెత్తంతా తీసేసి నీట్గా చదవాలి. Factories Act, first look at the definition of factory. 10 or more powers working is being carried on with the aid of power, without the aid of power. That means without using power. I don't know whether anybody is working in India without using power. Okay, but still the act says without using power. If some company is running, without the aid of power, 20 or more workers. 20 or more workers. Normally 10 or with the aid of power 10 or more workers, without power 20 or more workers. Any manufacturing entity is covered under the head factories. This is inspectors powers is also important. This is also same in gratuity PF Factories Act. Some inspector will be there. What are the powers of the inspector? What are the powers of the inspector? So at any time he can enter into any place, any business place, any company, and after entering the business place he will examine the machinery and all those things. He will inquire any person found there, enter, examine and identify who is having knowledge about the factory, inquire the factory and ask for the documents, So seize the documents, and then he has to take over this article, take possession of any article, means any good you can enter. So these are the powers of the inspector. Common powers. Common powers of inspector: enter any place, examine, inquire. Enter the premises, examine the things there, examine the goods and assets, and inquire the persons. Enter the premises, examine the goods and assets, inquire the persons, ask documents, seize documents, and seize goods or other assets. take possession of goods or other assets. Take possession of goods or other assets. Take possession of goods or other assets. Enter any premises, examine goods and assets, inquire the persons found there, ask for the documents, seize the documents, take possession of goods and other assets. Take possession of goods and other assets. Okay. So here welfare measures are different, and wealth related measures so this welfare measures is to provide for comfort. So is to provide for some comfort, and health is for safety. So this is a necessity. Health is for safety, and welfare measures are to provide some comfort. Okay. Health measures we'll discuss separately. So to protect the employees' health, they have to maintain all these things: drinking water. They have to ensure that overcrowding is not there. That means with less space, more workers should be avoided. Less space, more workers should be avoided. Less space, more workers should be avoided. Okay, overcrowding should be avoided. Ventilation and temperature should be properly maintained. Lighting, okay, lighting and ventilation almost same. Okay, ventilation and temperature should be proper. So this you can understand at least. No room in any factory shall be overcrowded to an extent injurious to the health of the workers. There shall be in every workroom in a factory of at least 14.2 cubic meters of space for every worker employed therein. 14.2 cubic meters, very important. So because practically these things, this lighting, etc., ventilation, etc., so this somehow we can manage. Even if something is violated, if the inspector comes, somehow you can request the inspector. But this thing is officially on paper. This thing is officially on paper. What is the size of our premises? How many employees are working there? That is on paper. Based on the provident fund record, they will know how many employees are working our company. And when we get a factory plan approval, when we get a factory plan approval, in that will give how much is the area here. So therefore outrightly will be booked here. Here it is not possible to manage. Okay, even if you manage temporary also, and so ultimately it will be very risky. So therefore this is the basic point. As a chartered accountant, we have to ensure the client is following at least these things. Otherwise, so there are many things in this point, okay, which is very difficult to follow. It will not work out to follow all these things. They will give, say, for every, if the factory is having 200 employees, there should be separate ambulance for the factory. I have not seen any factory having ambulance on its own. But the provision says if the factory is having some around 200 employees, there should be separate ambulance for that. I have not seen. So therefore there will be many provisions. They will say, so during this step from this place to that place, if the distance is this much, you have to put this many lights and this many fans. They will give all that calculations. That may not be possible. That may not be possible. But at least that the people will not identify. If the inspector comes also, say from this place to 1, 2, 3, 4, 5 fans are there. As per the rule, 6 fans should be there. In this place 6 fans should be there, and only 5 fans is there. Employee, definitely inspector will come for that only. Inspector also knows that 6 fans will not be there. That is the reason he will come. Okay, so if the 6 fans is there, he will not come. He knows that. Okay, offline payment. Okay, for offline payment he will work. So inspector will come for the offline payment. He knows that fans will not be there. He will say, sir, this employees are suffering, sir, because of immigration. No, because of suffocation, employees is not suffering. Inspector is suffering. Okay, so inspector will say, sir, six fans is not there. What is the how much penalty I should impose? So we'll say, sir, tell me your lucky number, some fancy number. Okay, that is the purpose. That some more people are managing practically, but this is not possible. Overcrowding is not possible because on paper it will be there. On paper it will be there. So what is the total length of the factory and how many employees are there? So 14 cubic meters for every worker employed there in every workroom. In every workroom separately have to see. Separately we have to see in every workroom, not the total factory. For every workroom we have to maintain this much of the capacity. And lighting, cool drinking water, okay, where more than 250 workers are employed, provision shall be made for cool drinking water during hot weather. The water points will be away 6 meters from. The water points shall be away 6 meters from a washing place, etc., or any other source of contamination. So that means drinking water and washroom should be far away. That's what they are saying. Drinking waters and washroom should not be at the same place. Minimum 6 meters away. Minimum 6 meters away. Drinking 6 meters. 6 meters is a very small distance, right? What is the 6 meters distance? Look at this here. Okay. So what is the welfare measures they have to provide? Washing facility. Okay. Factory should have washing machine. Any washing machine, LG, Samsung, etc., or Whirlpool, any washing machine. Facilities for sitting. Okay. Number of chairs, Nilkamal chairs, any chair. So they will give all this kind of list. That will not be there in the government offices, but they will ask all the factories to provide. Washing facilities, facilities for sitting, canteens, okay, first aid appliances, and appointment of welfare officers, and facilities for storing and drying clothing, whether we are staying in the factory or not. So intlo unnatuga ivanni undali. Facilities for sitting, so that even if you are working overnight there itself, all these facilities will be there. First aid appliances. So sorry, not 200. If a factory where more than 500 workers are employed, an ambulance should be, so nursing staff shall be provided. ఏ ఫ్యాక్టరీ ఉండమ్మా, నర్సింగ్ స్టాఫ్ ఫ్యాక్టరీలోనే అంబులెన్స్, నర్సెస్, మళ్ళీ నర్సింగ్ స్టాఫ్ షెల్ బి readily available at all times. First aid appliances during all working hours, or cupboards equipped with that. 150 workers at any one time in the factory. So how many first aid boxes we have to maintain at a time? If damage occurs to 150 workers, we have to maintain that much of first aid, they are saying. Not 150 workers at any one time. Suddenly some fire accident comes, some damage occurred to the employees, so you should be able to handle 150 employees at a time. So that much of first aid boxes may not be possible. That much of first aid boxes, they will keep hardly 1 or 2, right? 150 employees at a time. Okay, nursing staff. Canteen, if more than 250 workers are employed, there should be a separate canteen. The items of expenditure in the running of canteen which are not to be taken into account in fixing the cost of foodstuff shall be borne by the employer. That means that furniture in canteen, whatever the furniture cost is there, that should be borne by employer only. Only food cost employees will pay. Only food cost employees will pay. That furniture cost employer has to pay. So this will be there. That officer will not be there, but at least you have to write on paper. Welfare officer. Welfare officer will be there. Where is that welfare officer? That is important question. Which companies are required to appoint welfare officer? That is important question. So you have to prepare this list. If 500 or more workers are employed in a factory, the occupier shall appoint such number of welfare officers. So go through the material and list out what is important for canteen, first aid, ambulance, welfare officer, welfare officer. So what is the number of employees for each this facility? Okay, so what is the, when the which factories should this is the facility to be provided and this is the employees, this is the facility and this is the employees. So based on the number of employees, facilities provided will change. Based on the number of employees, facilities provided will change. So that you have to list out which facility, what is the number of employees required to provide that facility. And working hours also very important question, very important question, working hours. So we normally people will complain on this. Working hours provides for the working hours of adults. No adult worker shall be required or allowed to work in a factory for more than 9 hours in a day. For more than 9 hours in a day, 9 to 6. That's for normal business hours. Have you observed in the Companies Act? 9 a.m. to 6 p.m. That's what is this 9 hours. Okay, so that is the maximum working hours. Maximum working hours. No adult worker shall be required or allowed. Remember, shall be required or allowed. That means employer should not ask the employee to work for more than 9 months. If the employee himself is voluntarily willing to work for more than that year, even that also employer should not permit. Required or allowed, both. You should not say that, sir, employee is willing to work, that's why I am allowing him. No. Employer will escape based on that. Employee will work because of the job necessity. Because of the India is a country where there is huge unemployment. Therefore, employer will be in the dominant position. Always employer will be in dominant position because of unemployment in India. Even though working conditions are not good, many employees are forcefully working. How many employees are interesting or active in their job? No, many employees don't like a job, but because of the salary, because of the outside unemployment, they are forced to work. Therefore, employer will not say that, employer cannot escape that, no sir, I asked my employee to go after 6 p.m. but still he was saying. You have given that much of work. You have given that much of work, that is the reason employee is taking. Therefore, required or allowed. No required, no allowed. Even if employee is willing to work for more than 9 hours also, we should not allow the employee to work. No required, no allowed. Okay. Next, periods of work for adult works in a factory each day shall be so fixed that no period shall exceed 5 hours. That means before lunch, after lunch, you should give in such a manner that 5 hours continuously employee should not work for more than 5 hours. Okay, provided that the periods of work of adult workers in a factory each day shall be, the no period shall exceed 5 hours and the worker shall work for more than 5 hours before he has handed an interval for the rest of at least half an hour. That means for every 5 hours at least we should give half an hour break. That's what they are saying. Okay, 5 hours work, half an hour break. 5 hours work, half an hour break. Minimum half an hour break should be given. Of course, this will be there possible because if the employee goes at morning 9 o'clock, even if you have given lunch hours of 1 p.m., it will be 4 hours, right? 4 hours. Therefore, 5 hours you can work. After that, anyway, if the normally employers will provide 1 to 2 lunch. 1 to 2 lunch. That means 1 hour. As per that, half an hour. Though this provision practically many people will follow, but may not be this provision. Okay. So, shall not spread over more than 10.5 hours in a day. More than 10.5 hours in a day. So here 9 hours means 9 working hours. 9 working hours, 1.5 hours break. So total 10.5 hours. Maximum employee should stay in the company's premises. Maximum employee should stay in company's premises. Maximum employee should stay in company's premises. Okay, 9 working hours and 1.5 break hours. Maximum 10.5 hours. Employee should stay in company's premises. This is 48 hours in a week. 48 hours in a week. No adult worker shall be required or allowed to work in a factory for more than 48 hours in a week. Held that increase of 15 minutes working. Grace period. Okay, that is a case law. So 48 hours in a week means how many days you are working? 9 6 54. If the company is working for 54 hours, so this is not permitted. They are saying 48 hours. 48 hours in a week. No adult worker shall be required or allowed to work in a factory for more than 48 hours in any week. So that means even though daily 9 hours, some day you have to give less time. maybe half day like that, maybe half day. That is, there is 9 into 9 6 of 54. Therefore 9 to 5 days, full days will be 45. 9 5 of 45, right? So on one day will be 3 hours only. 48. So somehow you'll do, but ensure that not more than 48 hours in a week. Not more than 48 hours in a week. Even if in your articleship also this will be there, but people will not follow this. Even CA Institute says articleship not more than this many hours per a week. Okay. 48 hours in any week. Here the important point is that in the costing you might have learned about overtime, etc. So that overtime also there is a limit. Just because the employee is willing to work for overtime, we should not provide more overtime. That I'll come across. That is the important point we have to observe. So when you are paying salary, overtime salary, we should be very careful. Even though you are paying a salary, it becomes an offense. If you ask the employee to work, sir, employee has worked for 24 hours, sir, I paid 24 hours, it's an offense. So it's not that, sir, I paid 9 hours and I got 24 hours work. I paid for 24 hours and he worked for 24 hours. That is also offense. Therefore, very important, overtime you cannot take as much as you want. Okay. What is the first day of the week? That's why no worker shall be allowed to work on Sunday. Week starts from the Sunday, Monday, Tuesday, right? So therefore, so shall be no adult worker shall be required or allowed to work in a factory on the first day of the week. Normally people will call it as a weekend, right? So legally it is a week beginning, not weekend. Practical ga weekend antar kada Sunday ni, but legal ga that is a week beginning. Week begins with the, so therefore first day of the week means you are assuming Monday. No, not Monday. Sunday is the first day of the week. Sir, anyway Sunday is a holiday, but as per the Factories Act, Monday is also holiday. Don't misunderstand. Okay. So first day of the week means Sunday. So look at this point. So in emergency cases, you can ask the employee to work on Sunday. Normally employee should not work on Sunday. Normally employee should not work on Sunday. But what they are saying is that if suddenly some production is required, our customer is asking to deliver the product on an urgent basis. So in that case, I may ask the employees to work on Sunday. But what they are saying is that if you are asking this Sunday to work, say for example, 5th December, if they want to give a working day as 5th December is Sunday, yes, they can take. Due to the emergency work, employer can take, but 4, 3, 2. So either these days or 6, 7, 8. Employer definitely should give leave on these dates. Either 2, 3, 4 or 6, 7, 8. One full day. One full day employer has to give leave. Either before 3 days of that week or after 3 days, so that what happens is that you are not working continuously without any break. You are not working continuously without any break. Okay. So one day if they want to work, unless means they can work on Sunday, but whole day they have to get a leave. One of the 3 days immediately before or after the said day. Okay, if you want the employees to work on a particular Sunday, either you have to give a leave in any of the 3 preceding days or in any of the succeeding preceding days. Employer choice. Employer choice. Employer can provide leave on these dates. Employer can provide leave on these dates. Next, here in the given case, what happens is that you have to give a notice to the inspector. In the given case, you have to give a notice to the inspector. The manager of the factory has delivered a notice at the office of the inspector of his intention to require the worker to work on the said day. See, all this labor acts, though appears to be clumsy and not possible to practice, but they are very dangerous. These labor acts are very dangerous. So the danger comes when the ruling party is opposite to you. You are gone. Because since there are 1000 provisions and you have followed 20 or 30 provisions, gone, factory is closed. There are 1,000 provisions, and because of useless provisions, you will not follow. You will thought that no, it is a very basic provision, will not follow it. Therefore, there are many violations are there. That is a good thing for the government to lock down your factory and to ask for more amount or to ask for more. Therefore, we should keep in mind, though not followed in reality, at least create a papers that you have followed. Moral of the story is not, I am not advising that, may not be possible, but at least create a story or create a movie that yes, we have followed the pro. You have to arrange the paperwork, create the evidence, even if you have not complied the provisions, you have to create the evidence, either comply or create. What to comply? Provision. What to create? Evidence. Either comply the provisions or create the evidence. Not complied, not creating the evidence, you are gone. One day here what they are saying, if they want to catch, if they want the workers to work on Sunday, so they have to give a notice to the inspector. Sir, this Sunday I have more production target, therefore I am asking my employees to work on this day. This you have to inform to the inspector. 99% of the factories will not do it. In my experience, I have not seen even a single factory doing this. They will not do that. So now you are feeling that no, even though this many provisions are there, government is not asking you. Government will not ask you about this provision. But when government asks for some support from your factory and you are not giving that support, then they will open all these cases. Political party will come and say political donations will be there. You rejected. Why, sir? I should pay the donation. Okay, they will go back and they will open all these provisions. This will be 10 times more than your contribution. This will be 10 times more than your contribution. So small violations will be there, so which may result in closure of the factory. Okay, so therefore, so you should be very careful about this labor laws. Paperwork should be very pakka. From the beginning we should maintain the paperwork. From the beginning we should maintain the paperwork. Otherwise our enemies will be there who are ready to close the factory. Okay, for ready to close the factory, if you are not supporting the local political leader or the government, etc., so then they will open all these cases. Okay, that is the point. So therefore evidence should be very properly maintained on these dates. Shift duty, overtime. This is what I am searching for, that where a worker works in a factory, for more than 9 hours in any day or for more than 48 hours in any week, he shall in respect of the overtime be entitled to wages at the rate of twice his ordinary rate of wages. Okay, so overtime wages will be more than the ordinary wages. Where a worker works in a factory for more than 9 hours, so overtime wages will be, so these are all accounting entries you will write. At least write accounting entry, give cash, at least write an accounting entry, transfer this to the bank account and ask the employee to immediately withdraw and give the cash. That is what you have to give. Even if you say that, sir, I have given in cash, tomorrow employee said, no sir, employer has not given any cash, you are booked outrightly. Accounting entry, you are writing actual salary, but if it is less than twice the wages, so these are all the entries you have to monitor in your auditing. While you are doing audit, rather than seeing how much is actually paid overtime, check whether it is correct as per the Factories Act or not. So twice the wages, twice his ordinary rate of wages, 9 hours in any day. So if the employee has to pay twice his ordinary rate of wages, that means this is to discourage the employer from getting more work from the employee. To discourage the employer from getting more work from the employee. Okay. So this is double employment is prohibited. No adult worker shall be allowed to work in any factory on any day on which he has already been working. Okay, if you are following the news recently, there is a big dispute called as moonlighting. News watches no word telusuntadi. Software employees, because of work from home, they are working for 2 or 3 companies at a time. Since there is a work from home only, right? So I'll work for 2 companies or 3 companies at a time. Many software companies or many software employees who are working from home, they are doing that. So that is also this prohibition. So you should not work at a time in more than one employer. You should not work in more than one company at a time. So if you want to work for more than one company, you have to enroll as a professional outside consulting, not an employee. Not a full-time salary, not an employee, you have to work as an outsourcing. So you know these two, right? In the Income Tax Act, TDS deduction section 192, 194. 192 salary will come, 190 professionals. So you have to enroll for this 194 or what is that contract? 194J, 194C. C is contracts, right? J is professional fees are technical, professional fees are technical services. So if you are getting payment under this head, so okay. If you are getting payment under this head, you should not work in two entities. Okay, 192. Same working only, but you have to ensure that on this is what is creation of papers. Doesn't matter whether you call me as an employee or whether you call me as an outside consultant. Whatever name you call legally, it depends upon valid or invalid. Legally, if you call me as an employee, it is invalid. Two companies call me as an employee, it is invalid. One company is both companies are calling me as a consultant. Same work, same person, same salary. But the calling by name, the changes. Okay. If you change the section in the TDS, definitely you are safe. If you change the TDS section, then you are safe. This is a dual employment. This is also most expected question. Right. So here this is where the concept comes. Normally people are saying minor cannot work. So as per the Factories Act, minor can work. Look at this. A child who has completed his 14th year, a child who has completed his 14th year shall not be allowed to work in any factory unless a certificate of fitness is granted in the custody of the manager of the factory. And such child, while he is at work, a token giving a reference of such certificate. That means those who have completed 14 years and less than 18 years also he can employ. Minors also can be employed, but they should get a certificate that he was physically fit to work. Even though he is a minor, even though he is less than 18 years of age, but he is fit to work. He is fit to work. We have to obtain this certificate. Okay, less than 18 years also permitted. A person can work in factory, but you have to get the fitness certificate from the certified surgeon. So completed his 14th year and he has attained the prescribed physical standards. And this certificate is valid for 12 months. This certificate is valid for 12 months only. Normally employers, in my observation, I have observed employers are not going to take this risk. At least if the employee is 18 years major, then only they are not going to take this risk of taking small persons. But this you have to observe in small hotels. If you observe the workers, kids are working as a servers, for them it is risky. Small hotels, if they are recruiting kids as workers, then it is risky for them. Otherwise in big factories people will not take. One day for every 20 days of work permitted by him during the previous calendar year. So one day for every 20 days of work. That means 240 work days divided by 20. How many days they will get? 12 days. This is normally people will call it as a one casual day. One casual leave. That means one day you can take leave with wages. You can take leave one day per month, but you will get salary for that one day. If you take leave for more than one day, you will not get the salary. That is called as a casual leave. Okay. So 240 days you are working, and for every 20 days you are taking one day leave. Other than the Sundays and festivals, one day leave. Carry forward of leave. The total number of leave carried forward shall not exceed 30 days. So current month I don't have any personal work, therefore I have not taken any leave. Next month I can take a leave. Current month I don't have any work, therefore I have not taken any leave. But next month I can take the current month leave also, but carried forward should not exceed 30 days. Carried forward shall not exceed 30 days. This is encashment of leave. If a worker is discharged or dismissed from the service, he shall be entitled to the wages in lieu of quantum of leave. You know this in taxation, right? Income tax. Leave encashment. Okay. So shall be entitled to the wages in lieu of quantum of leave. This penalties only. That's all with the Factories Act. Okay, so you have any doubts, you can ask me. We have 5 minutes time. 5-10 minutes time ఉంది మనకు. ఏదైనా డౌట్స్ ఉంటే అడగండి.